One, I'd like to call the meeting to order for January 26, 2024. Can I go ahead and get a roll call vote from you, Devin?
Dr. Bolton? Here. Robert Brody? Dr. Cow?
Here.
Alex Chan? Here. Jim Efting? Here. Kareem Gangora? Paul Kramer?
Here.
Larry Kaplan? Here. Alex Lawrence?
Here.
Esther Lynn? Justice Misiwala? Bethany Peak? Ashley Silva Guzman? Here. Judge Reyna? Here. Vince Reyes? Here. Alan Yokelson? Here. We have a quorum.
Thank you so much, Devin. I'd like to start off the meeting with public comments. As noted on the agenda for today's meeting, public comments during the meeting will be limited. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. The committee has received and read all the written public comments. We thank you for that. We will attempt to call the members of the public in the order that they appear. To facilitate hearing as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers, and to allow the committee the time needed to deliberate on the important topics that we'll be discussing today. We will be limiting public comments to 3 minutes per person. For those of you who are participating via Zoom video, you should have a function for virtually raising your hand. It's a hand icon and should appear at the bottom center of your screen. If you wish to make public comments, please click on it. For those of you who are participating by phone, you may virtually raise your hand by pressing the *9. That's the star key, then the number 9. The coordinator will call members of the public in the order that they identify raised hands and will enable the microphone of the speakers. Are there any public comments are there any public members that wish to make a comment, Devin?
Yes, there are. Our first public comment will be from Benjamin Cohn.
Hello, good morning. I am first going to update that since the Board of Trustees approved the version you recommended of the testing accommodation rules revision initiative, I made some inquiries in behalf of others of the California Supreme Court to identify the proper way to be heard by the court as to its consideration of the rule revision initiative that will be moved. And after making those inquiries to Sunil Gupta, who I understand was the is the liaison for the state court in the state bar matters, I heard back from Jorge Navarrete, the clerk of the Supreme Court, that briefing will be invited within 15 days of the state bar's motion, responsive to that motion. And I understand that the state bar has not yet filed the motion, but when it does, I want to share that Charlene Kleisch will be making such responsive briefing and that I will be representing her on a pro bono basis. In doing so, the disability rights community will be asking, I believe, for the court to order right away similar reforms as were suggested in the public comment instead of those that were voted to be moved by the board and this committee. So I think you should be making planning decisions about what for the July 2024 exam you may be doing in regard to testing accommodations with those requests to the California Supreme Court in mind. Thank you.
Our next public comment is from Reverend Frank.
Good morning, good morning, good morning, and welcome to Cali Bar Corruption. Today we have Governor Newsom joining us. Governor, did you know that the State Bar of California is 100% corrupt? Oh no, I didn't know that. What's going on? Well, you should look at Leah Wilson and look at VanessaHolton.com. Oh my God, there's all kinds of videos now of you and Leah dancing and singing together. And a lot of the state senators too. It looks fun, fun, fun. Folks, I'm putting up a Twitch channel. I'm going to start broadcasting like this. I'm going to talk to the governor. I'm talking to Rob Bonata, and I'm looking for them to start an investigation. I told you this year, Leah, I am coming for you in an orange jumpsuit, and I am going to make sure that you, George, Ellen, y'all go to jail because you guys are really, really fucking over the people of California. The lies that the state bar is putting out, the fact that you're now using this term factual allegations. You know, again, that's telling us to go fuck ourselves because you just decide what is a factual allegation. So, Governor, come on, get back on this. Get up there with wonderful Bonata and get him to do an investigation into the San Rafael Police Department. I mean, there's documentation, there's emails that they kept the court. They kept this police report open for over 2 years to protect Vanessa Holton. Can you believe that? Oh my God, that's really just sick. That's violation of the Sixth Amendment. Yeah, I know, but these guys don't care because if you can't get them, if you can't take them to court, what can you do? I don't know, but some days we just like to have a whole lot of fun, fun, fun. My goodness, I got another minute to go on doing this. Hey, Senator Umberger, Senator Wilk, you guys are going to be pictured. What I'm going to do is take pictures like this of Leah, and there's a couple of programs out there, Hit Paw and Cutout Pro, and they make you sing, they make you dance, they make you chicken, they make you monkey, they make you do all kinds of fun stuff. And you guys up in the legislature, you're going to have to see some fun videos. But folks, this is what's coming with AI. So as you look at what I do and you look at the fight I've been taking, guess what? I'm going to take it up to the legislature now and scream and yell and embarrass them because this is an election year. Uh-oh, what's going to happen? Are we going to have fun videos of people getting out there in the election that are going to be fake? He's already seen it in the East Coast. So what's going to happen when it hits the West Coast? Governor Newsom, come on. Open up an investigation. I've got all the documentation there for you, and you just sit there and ignore it. I think I'm going to have fun with you until you start doing that. So you guys have an absolutely beautiful day.
We do not have any additional public comment. What is your name? Our next public comment is from David Linder. Yes, please.
Everyone can hear me now. Thank you. I just wanted to come and introduce myself. My name is David Lindner. Some of you may have heard of me, and others of you will be hearing more of me. I am here to go ahead, like I said, and introduce myself. There are some people in this room that have taken their powers and overutilized them, and that needs to be addressed. I look forward in the coming days to working with you to bring everyone to knowledge so that we can act as a unison, as an adjudicative body to maintain the integrity of this institution. Thank you.
Thank you. We have no additional public comments.
Thank you. Moving on to the open session, we will start with the approval of the December 1st, 2023 Committee of Bar Examiners public minutes. I'd like to go ahead and get a motion for approval. Thank you so much, Justice Masiwala, and may we get a second?
I'll second. This is Robbie Brody.
Thank you, Robbie. I'd like to open it up for any discussion about the minutes for the December 1st CBE meeting. Are there any edits or revisions? All right, seeing none. Devin, will you do a roll call vote?
Dr. Bolton?
Yes.
Robert Brody?
Yes.
Alex Chan? Jim Efting?
Yes.
Kareem Gangora? Paul Kramer?
Yes.
Larry Kaplan? Alex Lawrence?
Yes.
Esther Lynn? Justice Masiwala? Bethany Peak? Ashley Silva Guzman?
Yes.
Judge Reyna? Vince Reyes?
Yes.
Alan Yokelson?
Yes.
Dr. Cow?
Yes.
With 13 yeses and 0 nos, the motion passes.
Thank you. We'll go ahead and talk about the next item on the agenda, which is the approval of the December 14th, 2023 Committee of Bar Examiners public meeting minutes. I'd like to get a motion for that. Thank you, Justice. May we get a second?
This is Robbie. I'll second.
Thank you, Robbie. I'd like to open up see if there's any discussion or edits or revisions for the December 14th CBE public meeting minutes. Seeing none, Devin, can you go ahead and do a roll call vote?
Dr. Bolton?
Yes.
Robert Brody?
Yes.
Alex Chan? Jim Efting?
Yes.
Kareem Gangora? Paul Kramer?
Yes.
Larry Kaplan? Alex Lawrence?
Yes.
Esther Lynn? Justice Masiwala? Bethany Peak? Ashley Silva Guzman?
Yes.
Judge Reyna? Vince Reyes?
Yes.
Alan Yokelson? Dr. Cow?
Yes.
With 13 yeses and 0 nos, the motion passes.
Thank you, Devin. We're going to go ahead and move on to our next agenda item, which is the chair's report. Before we get into the CBE work plan, I would like to note that the committee, and for those members of the public listening in as well, that the committee will be taking a 1-hour lunch break at around 12:30 p.m. So everyone can kind of be aware of the schedule. Now, moving on to the posted work plan. At our last meeting, we discussed that about the 2024 work plan, and one of the takeaways from the conversation was to come back this month, which is January, for a sense of prioritization. I'm going to turn it over to the staff to discuss these priorities. So first, Christian, would you be able to talk about the moral characters?
Yes, good morning, everyone. So the primary focus for the moral character unit will be finalizing the revisions to the rules that we will discuss later today. Once those rules are finalized, they will be recirculated for public comment, and that is the focus for the moral character unit at this time. Does anyone have any questions?
Thank you, Christian. Amy, would you be able to discuss the priorities for examinations and then what is still called operations and management until the testing accommodation rules are approved? And at that time, we can change the subcommittee name.
Yes, good morning, everyone. So for the examinations, we have a few priorities. The first is developing recommendations in regards to certain exam components. I've raised this at previous meetings. This is the Access Lex grant that we are using to look at these exam characteristics. And so that is a priority that is ongoing. We started that in 2022. The next is to conduct a standard setting study to determine whether the passing score for the first year law student exam should be modified. We are going to discuss that at the March 2024 meeting. It is a priority. We're going to talk about it in the context of the evaluation of the score changing, given that with the elimination of the essay, we are now changing the scoring altogether, given that 50% of that exam was weighted on the essays that are going away. The next item is contingent on the court accepting the BRC recommendation that California develop its own exam. Should that happen, this is the recommendation that that exam be based on the CAPA recommendations. This is on the priority list for staff. The next item is also contingent on the Supreme Court deciding whether to accept the recommendation to start a portfolio bar exam as a pathway to licensure. If that were to be accepted by the court, then this is a priority for staff. As for operations and management, we have a few set of rules. The first is the special admissions rules that were approved here that are going to the board. They will be on the March 2024 agenda for the board. We also have the PTLS rule change along with the law office study, and that is on today's agenda. So this is a priority that is ongoing for us. I think that's all I have for both O&M and for examinations. Any questions? All right.
So lower on the list is, for instance, evaluating whether to phase out handwriting. Are those on the back burner? We can't really tell from this.
Yes.
Or do I tell from the lack of any entries in the three rightmost boxes?
Yes, correct. That we are, the priorities are the ones that we're tackling this year. And when those are done, or as we manage our schedule for the coming year, that could be raised as a priority, but we don't want to lose sight of the fact that it is something that we need to address.
Okay, one of those items is actually developing recommendations to assist the Supreme Court with the Blue Ribbon Commission report. And that's way at the bottom. Is it also at the top?
There are three entries related to that. So there's the BRC recommendation on the new bar exam. There's also a recommendation in there that's implied related to reciprocity. And maybe that's one that you're referring to that is not a priority at the moment, given everything else that we have for both examinations and O&M.
Okay, that's an awful lot to do. It's more than a one-year project, right, all of this?
Oh, yes. As you can see, the Access Lex grant, we don't anticipate concluding that until 2025. That is with a full summary. We will be conducting the actual experiment this year, but probably concluding with that initiative by 2025.
Thanks.
Mm-hmm.
Are there any more questions for discussion with Amy? All right, seeing none. Thank you, Amy. Oh, yes, go ahead, Donna.
Yeah, so, Paul, your question made me realize that maybe there could have been a little bit more of an introduction to this item. Just to make it clear to all of the committee members and the public, the organizational structure here. And Audrey, please correct me when I get this wrong, but what I believe you're seeing here is on this are all of the items that the committee has talked about in the past, and then staff added the priority column because, as you said, this is way too much to handle in 1 year. So staff went through and indicated what are the recommendations for what can be handled this year as maybe it was Amy just said earlier, to the extent that if any of these fall off the list, then we've got sort of the history of the others and they can be elevated. But this was an attempt to make sure that nothing that the CBE wanted on the list fell off, but that we do sort of capture what realistically can the committee and staff devote their time to this year.
And although none of the annual assignments are marked with an X in the priority column, they are, I mean, they have the priority that we have to do them every year. Okay, thanks.
Thank you, Paul. Thank you, Donna. Thank you, Amy. I'd like to move on to Natalie for educational standards priorities.
Sure, thank you, Dr. Kao. So in the area of ed standards, the two key priorities will be, first of all, the review of the unaccredited law school rules. You know that this body reviewed the accredited law school rules, and after a transition period, they're fully enforced this year. And closer, how about that? Better? Oh, good. Okay, so just quickly, as you know, this committee completed a review of the unaccredited law school rules, modifying them as necessary, went through a transition period, and they are in full force as of January this year. Now the review of the unaccredited law school rules will begin, and intertwined with that is the second priority for educational standards, taking a look at the option of a mandatory path to accreditation for unaccredited law schools, and figuring out exactly what would be involved with that, and bringing forth an updated proposal for the committee to consider later this year. Are there any questions? Thank you.
Well, actually, one, how many inspections do you think we'll be doing of schools this year?
Well, we're calculating that right now. We have about 6 planned, but we also think that there may be inspections related to the jointly accredited application process, and we'll need to see how many applications are received to determine the actual number. We're preparing for to be able to flexibly accommodate that demand if it should happen.
Okay, but we still have to describe the jointly accredited application process in our rules, correct? Or,
We're creating the staff materials to roll out as to that, yes.
so when do you think schools might be able to first apply?
I think that's a timeline of probably within several months, I think is probably a reasonable timeline. We are like reviewing the final draft of this application, so pending any feedback from others at the State Bar, I think that might determine the length of the timeline, but very near. But as far as your first question, Paul, I don't believe that the application process itself requires any additional rules. So we will have a finalized version of that application ready to launch, I believe, very soon.
Will we get a look at it before it goes out?
I believe we will definitely have stakeholders review it at some point. So I guess stay tuned and we'll bring some update to the committee
Okay.
probably in the next few months.
Thank you, Paul.
Thank you, Paul. Thank you, Natalie. Thank you, Cody. I wanted to thank the staff for your thoughtful prioritization. And I just really wanted to echo what Amy had noted, is that if we hear from the Supreme Court on the direction of the Blue Ribbon Commission recommendations and the portfolio bar exam pilot, those items are naturally going to be our main priorities as a committee this year. I wanted to ask, does anyone on the committee have questions about the priorities that we discussed? Or is there something that we would like to revisit? Or is there some additional priority that other committee members would like to bring up at this time? All right, seeing none, we will move on with our agenda. We will move to the consent agenda. And the consent agenda will be voted on and approved as a omnibus item, meaning one vote for the entire calendar, unless a board member wants to pull one single issue off the consent calendar. So I'd like to get a motion for the consent calendar. Thank you, Justice. May I get a second?
This is Robbie. I'll second.
Thank you, Robbie. Like to see if there's any discussion about the consent calendar. All right, seeing none. Devin, may we get a roll call vote?
Dr. Bolton?
Yes.
Robert Brody?
Yes.
Alex Chan? Jim Efting?
Yes.
Kareem Gangora? Paul Kramer?
Yes.
Larry Kaplan? Alex Lawrence?
Yes.
Esther Lynn? Justice Macy Walla? Bethany Peak? Ashley Silva Guzman?
Yes.
Judge Reyna? Vince Reyes?
Yes.
Alan Yokelson? Dr. Cow?
Yes.
With 13 yeses and 0 nos, the motion passes.
Thank you, Devin. Moving on to agenda item number 3, which is operations and management. I would turn it over to Tara to speak about actions on revisions to the practical training of law student rules, recommendations to circulate revised rules for public comment.
Thank you, Dr. Cow. Give me one moment to get my screen up. Okay, and so good morning, everyone. So, is it closer? Okay, better? Okay, thank you. Good morning, everyone. So as you may recall, these rules were before you previously. The last time was in March of 2023. From there, they went to the board, and the board did approve sending these rules to the Supreme Court. The court, however, in September of last year, did decline the proposal. They had expressed some concerns regarding the ethical implications of those studying in the Law Office Study or LOS program under a judge participating in the practical training of law students. So we worked with the working group to revise both the rules of court and the rules of the state bar. Here you can see we just briefly highlighted the most significant changes. So the rule of court, just removing the references to those in the LOS program studying under a judge, also adding an explicit statement that an applicant who's studying law in a judge's chamber is ineligible to become a certified law student. So trying to just make it very clear for the students. And then one was just a technical change, is just removing references to LLB since those programs are no longer offered, so no one would be actively participating in them. Okay, and so then for the rules of the state bar, we have a few more changes for you. Sorry, the microphone's a little tall. So again, removing references to those studying law in a judge's chamber. We also added a requirement of the PTLS where they do have to disclose any possible past or present conflicts, so that way their supervising attorney is aware and they can take action if needed. The rules as is, we added a couple other changes. We changed when an application is incomplete, the applicant receives notification. The way the rules are written now, they have 60 days from the date of submission of the application to cure the deficiencies. So we're extending that a little bit for them, and it'll be 60 days from the date of the notification for them. We also changed promptly for the notification requirements if the student is no longer eligible or the supervising attorney is no longer eligible for some reason, from promptly to 30 days. And a couple other technical changes, including a footnote reference to Rule 4.3 into the actual rule itself, and using the term receipt as it's defined in Rule 4.3 again. So just some of them are consistency changes, but mostly just to address the ethical concerns regarding those in the LOS program on a judge's chamber. And are there any questions?
So, let's see, it's first page of, bottom of the first page of the attachment B, subsection C, C2A. It says that they must have a first degree in law, and then it says acceptable to the state bar from a law school in a foreign country. I wonder if we couldn't cross-reference to the eligibility rule that describes what would be acceptable to us for both for the convenience, well, mostly for the convenience of the reader. Just saying acceptable to the state bar is rather vague and amorphous. Do you see where I'm looking?
Do I have it up correct on the screen?
It's too small, but let's see. Yes. So 2A there. where it says acceptable to the state bar?
That's something we can definitely look at as part of the motion. We've asked that the CBE grant staff permission to make non-substantive changes, so I think referencing a rule would be something we can definitely look into adding.
Okay, yeah, I also wanted to ask you about that. That's a new request, I think, that staff is making to clean up grammar and typos. And, but it's limited. It's not to change the meaning.
Correct. So
Or-
just cleaning up the rules, I think it's something I'd been informed had been done before with some of the ed standards rules, and just to make sure if there's anything we find between now and going to the board that we're able to clean it up.
And certainly if there's any questions, staff, about whether something crosses that line, we can build into that process that we would run any of those amendments by the working group so they can confirm that it's non-substantive before we'd move it forward.
Okay. And then, let's see, down in, right below that in paragraph 3 on the next page, in 3A, I have a feeling this would be too complicated to implement, but do we ever have somebody who starts studying in a judge's chambers and then eventually switches over to law office study? Is that even allowed by the program?
They could potentially switch their supervisor, but part of the reason that the working group decided to remove those studying under a judge, it's been such a small amount of students who participate in the program in that manner that was the way we felt it was best to address the ethical concerns.
Yeah,
So
that's-
it's possible, but I don't think it's a common situation that we see.
And trying to define when somebody could appear in a court who's currently studying with a judge is, as I understand, would be rather complicated and time-consuming. So I certainly respect that judgment. But if somebody is are you then considering somebody who had studied with a judge, even if they're now studying with a law office, to be tainted for these purposes by their previous association with a judge? Because what I'm thinking is if somebody takes their first year with a judge, then moves on to a law office and wants to get in this program, should they necessarily be prohibited because they're not currently associated with the judge?
I don't know if Donna has thoughts to add, but I think that the way we've written the rules, that if they're no longer studying under a judge, they would be eligible, and they would have that disclosure requirement to their supervisor, so then their supervising attorney would have to make any judgment calls if there is a conflict that arose there.
No, I think so long as they're not currently working for a judge, you think they would be allowed to?
Yes.
Okay, but then shouldn't we include study a first year in a judge's chambers as being qualifying? Because this deletion, in other words, I don't know that your interpretation of the rules with this being deleted is correct. This is a minor point, but I just noticed it. I don't feel strongly about it. As you say, there are very few people in this particular boat. So I'll just note it. And I think that's all I had.
No,
Yes.
I was just going to say, Paul, if you're a certified law student to practice, I don't see why you would need to be certified if you're just studying in a judge's chamber. That's how I understood it. So if you're going to appear in court and do things under the supervision of an attorney, then you need to be certified.
Well, but you have to qualify under these rules, and these rules seem to say, for instance, if you took your first year in a judge's chambers, you wouldn't be allowed to qualify to be in the program.
I didn't read it that way, but I don't know. Is that?
The intention, I think, was not to exclude them if they're no longer studying in a judge's chamber.
Okay, so long as they didn't take their first year in a judge's chambers, because you've excluded that. Okay, but it's not a hill I wish to die on. Or even get a paper cut.
Are there any other questions?
All right, are there any other questions or discussion for this agenda item of Tara's? All right, seeing none, I'd like to go ahead and get a motion. for this? Thank you, Justice Masiwala. May I get a second?
This is Robbie, I'll second.
Thank you, Robbie. Devin, may we have a roll call vote?
Dr. Bolton?
Yes.
Robert Brody?
Yes.
Alex Chan? Jim Efting?
Yes.
Kareem Gangora?
Yes.
Paul Kramer?
Yes.
Larry Kaplan? Alex Lawrence?
Yes.
Esther Lynn? Justice Masiwala? Bethany Peak? Ashley Silva Guzman?
Yes.
Judge Reyna? Vince Reyes?
Yes.
Alan Yokelson?
Yes.
Dr. Cow?
Yes.
With 14 yeses and 0 nos, the motion passes.
Thank you, Devin. Moving on to agenda.
We have to do B first.
Moving on to agenda item number 4, educational standards. We are going to temporarily talk about sub-item B first. Action on major change, voluntary termination of registration, Irvine College of Law. Natalie and Paul. Thank you.
Okay, thank you. I'd like to invite Dean George Leal and anyone else he may wish to bring for a public comment because I'll be asking for his participation in this item. So Irvine College of Law is a registered distance learning law school, and it has submitted a request to voluntarily terminate its registration. It is in fully compliant status. It has simply made a business decision, and the ownership group that owns this school is also involved with an undergraduate online university and is also the owner of Western State, an ABA-approved law school that it purchased several years ago. So it may be a business decision on the part of the school. They have submitted some preliminary information. They made this announcement on January 5th to the students. The school acted very swiftly to work with each student individually to create a transition plan, so swiftly that quite a number of the students were able to immediately transfer within this term and get settled in new schools here in California. The plan that they created in terms of the dates was clear in the motion, but as they're putting things together, they've asked for some brief changes. So I'd ask Dean Leal to speak to us as to the closure date that is requested and the date by which the full details of the teach-out plan can be shared. Thank you, Dean Leal.
Green, that should have told me something. Good morning, everybody. It's a real pleasure to see so many familiar faces and be back here in the building. Unfortunately, I'm not as happy to be here for the reasons that are now clear. Yes, as Natalie just outlined briefly, after quite a bit of time and effort and frankly a lot of money spent by our ownership to transform the school into a distance learning program, we tried our best to do what we had hoped to achieve, which was to attract more and better qualified applicants and students. Our long-term goal, I've been dean over 5 years, has been to seek accreditation, and pass rates with both the first year exam and the bar exam were very high in priority. So that was the aspiration and the hope, and I was given free rein to develop what I think is a exceptionally strong curriculum, and we did our best in marketing and with a new website, and we rebranded the name and the logo. And as an old antitrust lawyer and someone deeply that believes in the market forces, we have experienced the reality that in the last 2 years, the number of online JD programs have more than doubled. As the committee is well aware, I think the status now is all but one of the CALs offer some form of online JD curriculum and JD degrees. As a result, we just were not able to attract and enroll the number and the quality of students that we were looking for. We could have taken the easy route, which was to enroll a lot of less qualified students, but that was not my intent, and it certainly wasn't the intent of the ownership. So looking forward, given the small number of students that we were working with in the last 3 admission cycles. Running a school that now has a more expensive curriculum to offer with smaller number of students just was not economically viable. So it was a difficult decision to make. It was given a lot of thought and a lot of time, and the decision was made late last year, and our students were notified 3 weeks ago today. I can tell you, many of them were extremely disappointed. That I think they saw the number of students in their classes dwindling, and I think they understood the primary economic forces behind it. So since then, as Natalie has indicated, we're a small school. We had fewer than 40 students 3 weeks ago, and without an incoming class, we didn't admit anybody for our January start. And I personally have been working with virtually every one of our students. I just got an email this morning from students who had initially transferred to one online program and have decided to switch to another. And so I'm working with all our students, from our first-year students up through folks in their 4th year. We have one graduate who will graduate in June, and we have about 15 first-year students who will be completing their first-year curriculum at the end of this semester in June, and will then be qualified to take the October first-year exam. We have other students who are already eligible to take the exam in June. So I want to assure, I know this committee staff are mostly concerned, their highest concern are their students, and that's mine as well. And I can assure everyone that we have done everything. My staff, our registrar and assistant registrar, have been able to get transcripts sent literally within an hour or less of a request from a student. We send entire files. Everything we have for our current enrollment is online, so it's not difficult to do. With regard to the timing, I think I'll confess error. Our semester ends on June 29th, and why I initially requested that the school give up its degree granting authority and its operational authority on June 30th was not, as I used to tell in writing reports, forward thinking on my part in terms of what would be best for the school, our students, and our most recent graduate. So we have extended the 2 primary concerns that Ms. Leonard has expressed to me, and they're very valid, is what about maintaining our administrative office? And the good news is that we now have extended our lease through the end of July, so we're not going to need to move. We'll operate. I was there. We're busy working already trying to figure out how to scan and digitize our files. And it leads to the second issue, which is who will act as the custodian of records. And that's turning out to be a little bit more problematic. We've talked to, I had Zoom meetings yesterday with a company that does this, and they're preparing a proposal as to the expense. I've talked to the deans of 3 other registered schools, and one or more of them might be willing and able, with a proper agreement in place, to act as the long-term custodian for our records, for record requests, transcript requests from former students and graduates. It'll be simplified once we manage to digitize what is close to 40 years of records. Half of them, at least, are still hard copy. So that's going to take some time, and it'll take a little bit more time for us to identify the individual or entity that will act as our custodian of records. We haven't notified our alumni yet. Some know that we're closing the most recent ones, but I want to wait until we know who they could contact on an ongoing basis for records past July 31st. So I've just asked for a brief extension. I had initially offered to Ms. Leonard that we would be able to submit a TCHAP plan as early as the 31st of this month. I'd like a 2-week, maybe a 15-day extension so that I can have in place an agreement with our custodian, and I can report to staff and the committee who that will be. And then it's a very fluid situation with our students. As Ms. Leonard indicated, we have students who are still considering transferring depending upon start dates at other institutions. So by the middle of February, I think we will know for sure exactly how many students we will have through the end of our current semester. So with that, I'm happy to answer any questions or comments any committee members or staff would like to make. And again, thank you for your attention. Thanks very much to Ms. Leonard. She's always been very, very supportive of our program, both as we went through the transformational process and now, unfortunately, as we're closing down. So I want to personally thank her for her time and attention and expertise.
Thank you, Dean Leal. And to focus the discussion, we normally start by sharing the motion, but I knew there would be some changes. So we've placed it up for the committee to see, and then I'll ask to make those proposed adjustments. So the closure date moving from June 30 instead to July 31. And then the return of the teach-out plan as of February 15. Dean Leal, does that reflect the school's request?
Yes, that would be precisely. Thank you.
Yeah, perfect. So that would be February
Any
15.
questions of staff for
And then at
Dean
the
Leal?
bottom, February 15, that last date.
Alan?
Not a question, but a comment. George, we talked earlier about some of the successes that the school has had. You might want to share some of that recent appointment to the.
Well, that's very kind of you, Alan. Thank you. Yes, you know, I personally feel that it's like being, you know, the captain of a ship that is going down after 40 years. So I've taken this harder than I thought I would. The school has had a remarkable history, particularly in offering opportunities to law enforcement, and I think that's what's prompting Mr. Yochelsen's comment. We're very proud. We've had a long-standing relationship with the Los Angeles Sheriff's Department, going back, I believe, 20 years, where we offer law enforcement personnel a 50% discount on their tuition. And we've expanded that in this last year or so. We've contacted, in fact, we would have had 2 lieutenants from the Anaheim Police Department had we enrolled students in January. We have students from the Newport Beach Police Department, Fullerton, and one other. The successes are, you know, few but remarkable. I'm very proud of the fact last summer Governor Newsom appointed one of our graduates. Her name is now Judge Michelle Graves, who put herself through our program 20 years ago as a deputy sheriff in Los Angeles. She was a mother at the time and was able to juggle family, law school, and the rigors of a law enforcement career. She graduated, passed the bar, was offered by then the district attorney, Stephen Cooley, joined the department, the district attorney's office, and was a frontline felony prosecutor for 10 plus years. And then, given her background and ambition, applied. And it took a while, but she worked her way through the appointment process, and today is sitting on the bench at LA Superior Court. We have other deputy sheriffs. I have one who's studying today for the February bar, and I'm pretty confident he's going to pass. And we have several others. One who teaches as a graduate of our program and is an excellent professor. And you know, they attribute their opportunity to come to Irvine as to their success today. So we thank you, Alan. We have many other graduates who are private practice, but the law enforcement personnel and giving them the opportunity at the cost of what they pay compared to other programs, I think, is a credit to our ownership, and I appreciate the opportunity to make that a public comment.
Thank you, Dean Leal.
I had one question, Natalie. In the staff report, you say you're awaiting a list of the remaining students to reinforce this key message. Does that mean you're going to be reaching out to each of the students, or?
We generally do send a communication to the students to let them know their transfer options, the ability to request an evaluation of study to date, et cetera. And actually, subsequent to the writing of the motion, Dean Leal provided that list. And the school has been so proactive as to counsel each. So several are already settled, and several have asked us questions, but the questions evince a real preparation on the part of the school's administration. So I want to thank you. But yes, we do. We always do.
And if I may add just a comment, and again, for thanks, a number of the schools have wisely suggested, and I think at your suggestion, Natalie, that our students have a review of their transcripts to make sure that the school they transfer to know exactly how much, I call it CBX eligibility credit they have moving forward. I'm pretty good at reading transcripts, but the folks down the hall are the final say. And so we're assisting them by submitting, signed, sealed, hard copy transcripts for that review. And it's an excellent idea. We've done it many times for our students as well. So they can then move on with their legal education, secure in the knowledge of how much more time and effort and years of study they need to become eligible for the bar exam.
So this ensures not only maximum credit, but also minimum disruption for the students, and I've greatly appreciated the collaboration.
Hey, Dean, this is Alex. Got questions for you. I'm just reading your letter. How many students are in their 4L at this point?
At the moment, we have one. The
Okay.
3 or 4 that were, by coincidence, a majority of our second, third, and fourth year students had just completed their an academic eligibility year in December. And so what I had advised each of them was it would be better for them to transfer as soon as they could and earn their next year at the new institution instead of doing it at half years. You can earn, a half year of credit for eligibility at a time. And the fourth year, there were 3 fourth-year students. Again, just to tell you who they are, one of them who's a student I've enjoyed watching her grow. She's a national Vietnamese native who is doing phenomenally well in our program and spent most of last semester in Vietnam. Her mother was sick and passed away, and she never missed a class because of the benefits of Zoom and the internet. And she and 2 of her classmates have transferred to, I believe, Pacific Coast University, which has a similar program. So the 1 4L we have, and I was just emailing Adaptabar to make sure he has access. He's in our prep course. Will finish out his career and graduate in June. We have probably 4 or 5 second and third year students, and then, as I said, I think about a dozen first year students. So we're half of where we were, 3 weeks ago.
So for the 4th L, for that one student that's graduating, would that person be receiving resources in terms of preparing for the bar? I think you mentioned at the bar, so it sounds like they are receiving.
Oh, yeah, in fact, yes. I just 10 minutes ago, we use a company called Adaptabar. It's West Academic. It's a testing platform for multiple choice questions. And we use it regularly and vigorously in all our classes. But for our fourth year students, we have a prep course, and he will spend 270 hours both with a tutor and on Adaptabar and all that. So the question was getting him, they had made a mistake. We have our first years have limited access to only 3 subjects that are tested by the first year. He needs access to all subjects tested. And he logged on this morning and he couldn't get into civil procedure. And of course I got an email saying, what's up with that? And I just emailed the Adaptabar rep. So yeah, we're committed, and he will receive every bit of resources and support that any of our prior graduates did prior
And
to the
for
course.
any other 4Ls that are not graduating, they also will be transferring and receiving credits.
Yeah, if I understand your question, yes, the 3 that I mentioned, they just finished their third year in December, and now they need 1 more year of eligibility credit, and that's why they've transferred as quickly as they did, because, well, actually, they transferred to a school that was starting literally the week that we announced we were closing, and as I found out recently, they've decided Pacific Coast University has a little later start date. I think Dean Desi's told me it's February 12th, so they can make that change, and they'll start their fourth year they'll start their third year, I believe, and then the 3 fourth years I mentioned will start their fourth year on February 12th.
Got it. That's what I wanted to know. Thank you.
Somebody want to make the motion? Okay, Justin? Thank you, Alan. Devin, any further discussion?
I have a question, if I may.
Go ahead.
Yeah, thank you for coming today and kind of sharing some of your feedback. Is there anything, I guess, that we do, Natalie, as like an expert interview to kind of understand the situation the school experienced? I know there's been some challenges in the industry. I understand, there's overall societal issues occurring too. Is there anything that we would capture out of this to kind of use as a best practice moving forward?
I couldn't have paid you for a better introduction. The next topic that we'll be discussing is the law school profile report and giving an update on some ABA actions to talk about the legal landscape and the types of regulatory changes the committee may want to consider.
Devin?
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Alex Chan, Jim Efting,
Yes.
Kareem Gangora,
Yes.
Paul Kramer,
Yes.
Larry Kaplan, Alex Lawrence,
Yes.
Esther Lynn, Justice Macy Walla, Bethany Peak, Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes, Alan Yokelson,
Yes.
Dr. Cow.
Yes.
With 14 yeses and 0 nos, the motion passes.
Thank you, Devin. We're going to go ahead and move back to subsection A, action on profile of California law schools. Natalie and Paul, can I turn it over to you?
Thank you, yes. Let me move this close enough to me. Okay, thank you. So we'll bring up the slideshow regarding the law school profile, and to Kareem's point, part of the idea here is that you really are at a pivotal moment in the legal education landscape right now. We're coming out of COVID, a lot of things were learned there. The ABA is making some significant changes in what's allowed at that level, and we're bringing you more data as you embark upon another rules change for the unaccredited law schools and potentially evaluation of mandatory accreditation. So today we'll bring you the law school profile report, and so we'll just advance to the next slide. And one more. So the purpose is really to effectuate a Board of Trustees goal and also a goal of this committee. On the State Bar's strategic plan, there's a goal to protect the public by enhancing access to and inclusion in the legal system. And one of the subparts of that is collaborating with stakeholders in law schools to improve the law school accreditation process. And on the next slide, we'll see, we just talked about a little bit the work plan, which includes potentially pursuing mandatory accreditation and possibly additional initiatives to improve outcomes for accredited law schools, including evaluating the unaccredited rules and metrics, and then, of course, effectuating the State Bar's strategic plan. Next slide. So just to recap for historical purposes, but also for the new members who have joined us since, back in August, you took a look at the 2023 accredited and unaccredited law school performance report. So that's an annual snapshot of performance for just those groups of schools, the accredited and unaccredited. The idea is that that was the first time to see that. There's a consideration of those metrics, whether they should be changed or expanded in the future, and you'll be seeing that every year as essentially a diagnostic report card of the schools, and the link to that for the public is there on the slide, which is posted on the agenda. So against that backdrop, today we're bringing you a related but different report, and it's got a view that we haven't seen before. It's comparing the outcomes and the performance of all of the different schools, ABA approved, accredited, and unaccredited. They each operate pursuant to different rules. They each have different purposes and places in the legal education landscape, but it is helpful to see what the outcomes are for each of these. And this is the very first comprehensive report that looks at all of the 3 types of law schools in California, which has a very unique legal education structure versus any other state in the country. For the public, the link to that report is here, and we've brought Dr. Lisa Chavez from our Office of Research and Statistics, with whom we collaborated to create the law school profile report. She's attending remotely, and I'd like to introduce Dr. Lisa Chavez. Thank you. And then we'll just take her off mute, and we'll just take her off mute, and then we look forward to hearing her comments.
Hey,
Well, good morning. My name is Lisa Chavez, and I'm the Director of the Office of Research and Statistics at the State Bar of California. I'm delighted to give you an overview of the report, what we call the California Law School Profile. And as Natalie shared, this report explores California law schools in all three categories: those accredited by the American Bar Association, those accredited by the State Bar, and those that are unaccredited. I'm going to start sharing. So the purpose of my talk today is to just to walk through the report for you. Can you see my screen? You see the report? The purpose here. Okay, and the purpose is just to really, I'm going to just walk you through some key findings, how you could, we're hoping you, the public, all our stakeholders get out of the report. And of course, I'll be able to take some questions to you, questions as we go along. Feel free to ask me questions, or we can take them at the end. I'll leave that to you, Natalie, to decide. Okay, so let's get started. So just, again, this is what's a really nice development for the State Bar is now we produce reports in Folion, which makes the reports available online versus, in a PDF format. And so you click through all the different pages online, and here we have a nice executive summary. Here is the methodology. Here's the table of contents, and here you can click and it'll take you directly to the sections of the report that you wish to see very quickly.
Dr. Chavez, can
Yes.
you maybe get closer to your mic or something? You're a little bit muddy room here.
How about now? A little better?
It is, thanks.
Okay, thank you. Okay, this is a page on methodology. Here's where you will see the descriptions and explanations for the extensive sources of data that we have that we accessed for this report. So now let's get started. Okay, so this section, which is an overview, is meant to, it really takes the reader down into these three types of law schools in California. As you can see, we have little descriptions here. We have a little call out box that describes the work of this committee. And here's just to really just orients the reader and takes a zoom out and says, okay, in 2022, there were 48 law schools in California. And it shows the distribution for each of the three different categories. On the right reflects out of those 48 schools, 17,100 plus students were enrolled. And the purpose of this chart and the way we oriented it this way with two pie charts is to show that even though the ABA approved schools comprise 38% of the 48 schools, they serve the vast majority of all 17,000 students enrolled in law school in California in 2022. And then this table is meant to just give a little bit more context to that. So why is it that they serve the majority of students? It's because on average, they're bigger. The average of JD enrollment at ABA schools is over 600 students. And as you can see, CALs are the next biggest, with unaccredited being the smallest. Here's the total JD enrollment for each of the categories, again, aggregated at the three different levels. And on the right here is the average total cost to complete a JD. So it's not an annual cost, it's like the total cost to complete a JD across these schools. And again, this is an average for each aggregated category. This figure here takes the reader down into the history of these schools, and really just shows we chose 2009 as our starting point for this because that's where nationwide there was a big shift in law school enrollment and for ABA schools as a result of the recession. And so what the takeaway here is the ABA schools, they're only declined by 2 over the last, since 2009. But the enrollment really dropped across these schools. So even though 2 schools closed or ceased being ABA schools, ultimately that enrollment dropped. And this, we discussed in the report that this mirrors national trends. This figure here describes the CALs and how they have changed over time. So as you can see, we've added 4 more CALs, but the enrollment increased very dramatically during this time period. And we explained in the narrative that it had to do with a couple of schools converting from unaccredited and gaining accreditation. And this last figure here talks about the unaccredited schools, and it makes the point that in 2009, there were 25 of them, and it dropped down to 12 as of 2022, and enrollment changed as a result. So that's a big, really like overview of the 3 different types of schools, how big they are, how many students they serve, and how that's changed over time.
Before you go off of that, can I ask you a question? So
Absolutely.
among all the schools, ABA and California accredited and registered, is the number of students pretty much level over time then? So we haven't seen a drop in the people studying law so much as the allocation among the different schools? Is that fair to say?
I don't think so, because I think if you were to add this up here, like I said, there was 17,000 students enrolled in 2022. So I think here, if you look at the number of students who were enrolled, if you added these 3 numbers up, it's over 20,000. So overall, there were fewer students enrolled in law school, I would say, compared to 2009.
So
You
for those
disagree,
of
or-
us,
Sorry,
for
go ahead.
an agency trying to increase the number of lawyers, the pipeline's not really doing very well for us.
Well, certainly the numbers have declined, that's for sure. The numbers of people who graduated, but that's something to just think about, is that many of our people who are admitted to practice law in California come from schools outside of the state. So that's just another kind of element with regards to California's law attorney population. But yes, in California, ultimately, there are fewer students attending law school in California.
So, but there has been, well, remind me, Audrey, Amy, or Donna, are we seeing a downward trend in the number of applicants for the bar exam over the past few years?
That didn't happen for this exam. That trend happened probably maybe last year, but this year we've seen an uptick.
We are now seeing an uptick?
Yes.
Year over
Okay.
year for the exams, yes.
Okay, thanks.
Great, so let's go on to the next page. Okay, so this page here, called Student Diversity of California Schools, looks at the diversity of these 3 different types of law schools in 2 different ways. First, it starts with those 17,000 students, where do they enroll? So that's this top bar right here. So out of those 17,000 students, the majority of them are enrolled in an ABA school. 27% are enrolled in a Cal, and 4% are enrolled in unaccredited schools. And this shows that this varies by race, ethnicity, and gender identity. Another way that we look, and then so what's not what we a different one approach we took is that we report out results by by the intersection of race and gender. So here's white men, white women, men of color, and then we also disaggregate further for people who identify as non-binary. But then we also make it a point to really explore how it varies by different racial ethnic groups. And so what this figure shows is that there really is variation by race and ethnicity on where students attend school. And something that should really stand out to you right here is, for example, half of all African-American law students in the state are attending a CALS, for example. So let's scroll down, that's one. Okay, then we approach it a different way. We flip it around and we ask, looking at each different type of law school, how diverse are they? And we make it a point to compare that diversity of the schools to the California adult population. And what this figure shows right here is, I'm going to make this smaller so it can fit a little bit better. What this figure shows is that here's the California adult population on the left, on the right, and people of color are 62% of the adult population. If all the different types of schools were similarly diverse to the state of California, these bars would look similar all the way across. But in point of fact, that's not true. And what this shows is that the CALs and the unaccredited look more like the racial ethnic diversity in California than the ABA approved schools. And here is again the number of students that enrolled here in the different types of schools. Same thing with gender. We also explore gender. So women are 50% of the adult population. And really the unaccredited schools look more like the women population in the state. And again, we do the same approach down here. Again, looking at our different intersectional categories, and it shows that what's interesting about this one is a couple of takeaways is that women of color are the largest group of students across all three different types of schools when examining this enrollment. So that's this bar right here. So women of color are 32% of the state. They're 29% of ABA, 32% of CALS, 29% of unaccredited. And here's just again looking at it by race ethnicity, and we see that Latino law students in particular are significantly underrepresented at the state's law school. So Latinos at this point are 32% of the state, but they're only 20% of at ABA approved schools, 25% of CALS, and 18% of unaccredited. So these are just the way like you should make use of the different types of figures in this section on diversity. Okay, so let's move on. Other key findings. Okay, so next we turn to attrition. This has to do with student outcomes, and we focused on the transition from 1L to 2L. And in particular, attrition means the percent of students that did not come back for their second year. And this is the way the American Bar Association regularly reports out on attrition, and so we follow the same model. And so this chart here, and we also have data on what the reason was. So people either tried it for academic reasons or other reasons. And other is just this big general category. What you should see immediately in this figure is that the students at unaccredited schools have higher attrition rates. So as you can see, so 51% of students who start off at an unaccredited school do not return for their second year. CALS are next at 42%, and ABA, it was 8%. And then what also you should be able to take out from this is that when you look across the three different schools, all groups are having, if you categorize it by white people, color, men, and women, there is some variation, but overall, like the pattern of like unaccredited, like all the groups have higher attrition at unaccredited, less so at CALS and less so at ABA. That's what you should get out of this figure in particular. So let's scroll down to this one. Here we go even deeper into different racial ethnic groups. And what you should see here is that what really stood out to us is that nearly 70% of Black students at the unaccredited students did not return after their second year. But again, even we explored, but the ABA, even at the ABA approved schools, you see that some groups have higher attrition rates than others. So even though, attending an ABA school, you're less likely to experience attrition, still when you disaggregate by race ethnicity, we do see disparities there with groups like American Indian, Black students, and Native Hawaiian students having much higher attrition rates at the ABA schools. Okay. And then next we looked at JDs awarded. So again, like we just took, again, zoomed out, said, okay, in 2022, there were 17,000 students. The ABA schools enrolled 69% of them. Then we said, okay, in 2022, how many JDs awarded across the state? There were 4,500 JDs awarded across the state, and the ABA awarded 87% of those schools. Sorry, of those JDs awarded. They awarded 87% of those JDs. In contrast, the unaccredited schools awarded just 72 JDs in 2022. That's what that little 1% translates into, 72 JDs. Here we have the data disaggregated by race ethnicity and gender identity. We chose instead to show the numbers for this table rather than percentages, just to really show, because this is really about individuals and about how many number of people who are exiting these schools and moving towards taking the bar exam if that's their choice. And it just really takes you down. And really the point you should take here is that, let's look at the point we make in the report is that in the end, people of color were interested in improving a diverse legal workforce. The ABA schools awarded 1,600 JDs to people of color. The CALS awarded 280, and the unaccredited awarded 37. So even though the unaccredited schools and CALS unaccredited schools are more diverse, and represent the state of California more so than ABA, because the ABA schools are bigger, because they have lower attrition rates. In the end, they are producing, nearly 2,000 people of color attorneys, potential attorneys every year, and much less so for the CALs and unaccredited. And then next we look at bar exams. So we, acknowledging, of course, that not everyone plans to practice law, so they don't take the bar exam. We still, ultimately, we have really great data on the people who take our bar exams and what schools they came from. And we honed in on July 2022 in particular. And what you should take out of this chart is that, we disaggregate, like these are the people who took the exam. This isn't pass rates. This is who took the exam. So among the ABA approved schools, the majority of them were taking them, of all the bar exam takers who graduated from an ABA approved school, the majority of them were first timers. In contrast, of all the people who took the bar exam from a CALS unaccredited, they were taking it on a repeat basis. So this confirms, what we know, that that it kind of gives credence to the idea that these schools have lower pass rates, but that will be more clear in the next figure. So this is actual pass rates here. And again, it just shows that in general, if you were in your JD from an ABA approved, we have higher pass rates, whether you're taking it as a first timer or as a repeater. And here we disaggregate it by race ethnicity. And this really just makes the point that, Asian, Latino, Black applicants have lower pass rates than white applicants among first-time test takers, regardless of the type of school that they attended. And then here we look at it over time, just pass rates in general by the 3 different types of schools over time. And this makes the point that ABA schools, if you graduate from an ABA school, your pass rates are much, much higher than pass rates of those who graduated from a CALS or unaccredited. And again, here we we kind of aggregated all the data for the last 10 years. See, this reflects 2012, 2022. And it just shows, and again, what you should do, again, zooming out, again, pass rates for students across all groups are nice and high, much higher at the ABA approved, less so at CALS and unaccredited. But even then you see variation within each type of school. So for example, African Americans attending IBA schools have pass rates of 54%. And in other, and there's we point out in the report, there's other patterns we see as well. Let's see if there's a bullet point here that just makes that point. Yeah, so over the past decade, Asian, Latino, Black, and other students consistently had lower bar exam rates. Okay, so those are the main topics that we reported on in this report. And here at the last week, here are our key findings. We really strove to again, zoom out and take the reader in for each one of these 3 different types of schools. What do you need to take away? What is the point we want to make? What is the biggest thing we learned? So here on the left, we just summarized what we learned about the unaccredited schools. And the bottom line is that, just as we say, it really underscores the substantial obstacles students face when they attend an unaccredited school for those who want to become attorneys. At every step of the way, they face a lot of obstacles. There's also some challenges for students attending the CALS. They have a 42% 1L attrition rate, and their bar exam pass rates are much lower than those of the ABA approved schools. Now, even though the ABA approved schools have much higher performance rates overall, we do see that there are challenges for some racial ethnic groups attending the ABA approved schools, particularly Native Hawaiians and Black students and American Indian students. So our big conclusion on the right with regards to diversity is that the future of California's attorney diversity population is driven and continues to be driven by ABA approved schools, despite their enrollment not reflecting the state's diversity. And again, that has to do with their size, their lower attrition rates, and their higher bar passage rates. All right, so I will take any questions you may have about the report, our methodology, or any of the key findings I described.
Questions, anyone? I had one. Did you have a question, Robbie?
I guess I do have one for our speaker, and thank you for that.
Get closer to your mic for her sake.
That was an eye-opening presentation, I have to say. I don't know if this question is for you or for Natalie, but what do you think it is about the unaccredited schools that so poorly, or I suppose, I guess you can, poorly prepares those students to take and pass the bar exam?
Well,
I guess that's what we want to know.
I think there are a number of different options, and while the ultimate motion that we'll ask you to make today regarding this item is just to receive and file the report, in the next couple of slides, we'll show you some of the things that we think are going on and just introduce some possibilities and encourage brainstorming about actions that the committee can take to improve the outcomes.
Thanks, Natalie.
Larry? It's not on. See the green?
Ah,
There you
got
go.
it, okay. Those are raw numbers though, right? So the unaccredited schools, they're smaller, they have fewer students, blah, blah, blah. That's part of the reason that the numbers are so low, right?
Yeah, some are not, and the largest ones actually became accredited in recent years, but most of them are smaller.
So that would account for what Robbie noticed, which I did too, but I just figured that they're smaller, they have fewer students, so they're gonna have fewer passes.
I think Robbie was asking about pass rates. You know, percentage of the smaller number, what
Oh,
percentage of them?
percentages,
And
okay.
it's a lower number than for ABA
Right,
schools.
right, okay.
So Dr. Chavez, this report will be refreshed periodically, is that correct?
The data in this report, much of it is overlaps with the law school performance report, and that report will be refreshed on an annual basis.
Okay, I was wondering, there's no socioeconomic measures in here, and maybe it's really hard to get, but you know, the relative economic prosperity of the students is a factor in some things. For instance, tending to favor law schools that are less expensive. And I wonder if it's possible to gather that data for future analyses, or is it just so hard to get, or is the reporting so unreliable that it's not going to be meaningful?
The American Bar Association does not require its schools to report that detail for its students. So we can, as of now, the State Bar does not require schools to report that information for its students.
Do you see any value in obtaining it if we could?
I can see that. I can see that. But if the State Bar was to move in that direction, we just wouldn't have data to compare it with the ABA.
Yeah, so it'd be half an effort is the best we can do. Okay, thank you.
Mhm.
Any other questions?
Paul, I have a question. Dr. Chavez, one of the things I was looking at, I mean, the data is like what Robbie said, eye-opening. I wonder, do we have a data set on age demographics? Because if we're going to try to tease out, you know, how we can change those numbers moving forward, I'm interested to see what the age demographics are for ABA versus Cal versus unaccredited, and does that have any potential implications, i.e., maybe students who go to Cal and unaccredited are working and they have a lot more than on their hands than just being a full-time law student?
At this time, we do not collect information on age for on students enrolled at the Cal or the unaccredited, and I do not believe the ABA requires the schools to report that as well.
Thank you.
Okay, so there's more to the presentation, so let's go forward.
Sure. So Dr. Chavez, I want to thank you for joining us, and to the extent you're available, we'd love to have you stay for the next part of the discussion. At this point, this is really just an introductory thought to get some initial feedback from you. But thinking about, based on the data that you've seen both in August and today, we have a couple of ideas to discuss, and we welcome yours as well. So this is actually taken from the data in the law school profile report. It's essentially a funnel summarizing the data that we talked about. And we see that the most challenges are faced by students in unaccredited law schools, and consistent with your priorities to work on the unaccredited law school rules and to consider mandatory accreditation, your choices may be right on task. And I believe this is a really visually impactful slide. So how can this happen? Let's go on to the next slide. One way is to think about changing or enhancing the way that we measure outcomes, and you're starting to see that in the comments and questions from the measures already that the members are asking. One thing we did was look to the accredited law schools. So they are having improved results, and this could be because of a composition of the student body, as the members raised, but also there are some different things in those rules that you might want to think about expanding in an appropriate manner to the unaccredited arena. And in particular, there's a mandatory minimum bar pass rate for accredited law schools that's been very helpful, and it might make sense to have a mandatory minimum for both the first year law students exam and the bar exam for unaccredited law schools. And we have some additional slides about what that has meant for the accredited law schools since it's been introduced, if that is interesting to you. And Paul, I'll leave it up to you to think about if you want to discuss each of these bullet points a bit as we go through them, or perhaps go through all four first.
People can ask questions as we go along if they come to them. But again, to emphasize, today is to get your thinking caps activated and decide if we want to further investigate any of these or all of these proposed changes to our requirements to address what we've seen in the statistics and the report we just reviewed. Yeah, let's see how much depth people want to go into based on their questions, I would say. Does that make sense?
Okay. Perfect, thank you. Another difference is the increased availability of practical skills training. So both law school sets are required to include 6 hours of practical skills training, but the accredited schools are also required to have up to 15 hours available. So that's more opportunity for writing practice, more opportunity for trial skills practice, and potentially we could see the impact of having those options available, how many are choosing those options, and what the result is going forward, balancing the need to have enough time on the doctrinal courses targeted toward the bar exam. Two other additional newer possibilities in the unaccredited rules that are now in full force as of this year. First, for the first time, they include a diversity plan. So a key reason for having these schools is to increase the diversity in the legal profession. But now, for the first time, each school will have not only a written diversity plan with metrics that recognize their mission, they're also required to evaluate those, make decisions based on the data that's found, and report those decisions to the state bar. So we'll be bringing that to you. But we're excited about the possibilities that could come from that. And also we're excited about the creativity the schools may bring to creating helpful metrics. And then finally, there's a section of the accredited rules that talks about encouraging licensure and professionalism. So a whole section of the rules is about making sure that whether a student decides that they will want to take the bar exam or not, that as many students as possible, and ideally every student, will leave the program equipped to pass the bar exam if they so choose. To the extent that we wanted to give a little bit more data about the MPR for purpose of history for some of the newer members, the MPR has been a very helpful measure for a number of reasons. First of all, it's obviously aligned with the goal of licensure. It recognizes the proportion of graduates that have licensed in California. And it's also been a very flexible outcome. As the licensure possibilities have changed, this elastic measure has been able to incorporate that. So when the PLP expanded pathway to licensure was introduced, that was incorporated very smoothly into the NPR, and it also protected the privacy of those students that, and ultimately graduates who decided to license via that method. In addition, we saw a great increase in the number and type of bar prep options, not only for the students, but also a continued support for the alumni that we hadn't seen before. And that's really important in this segment of schools where you see a much higher percentage of repeaters, so they may remain supported even after they finish their specific JD program. The other thing that we see is that on balance, we see the NPR continuing to rise at the accredited law schools, even though the actual minimum has not changed. So now schools know they're being measured, know that prospective students can look at this, and it's been a focus that has driven success. And in addition, for those schools that are not able to achieve the minimum, it gives you a very neutral measure to help those schools to decide whether to continue or to transition to a registered status. Next slide. Thank you. So if we were to translate this to the unaccredited world, it would make sense to think about both of the state bar exams that are required toward licensure, both the first-year law students exam and the NPR. We don't have a specific proposal to bring to you today, but we could adjust it to the timing and the timeline. The reason why a 3-year rate is suggested here is because when students attend an unaccredited law school, they must take and pass the first-year law students exam within 3 opportunities to do so. And if they are not able to do so, then they're dismissed from their law school at that time, and they can return to law school upon passing. So a different time frame may be warranted. Okay, let's go to the next slide. Thanks. This is a very elegant measure because it really hits all of the aspects of the things that are important in an education. It encourages the schools to think about the students they're admitting. Are they admitting the kinds of students that can benefit from the actual program and resources that the school can offer? It'll encourage the improvement of the first-year law students exam state bar results. Hopefully, it'll encourage the progression of students and reduce attrition, leading to graduation and ultimately licensure. And if you're thinking about other measures, I would encourage you to consider some of these buckets as ways to brainstorm about other measures we might include. So let's stop there.
Natalie,
Yeah.
Can I jump in for a moment? Sure, I'm sorry. And I apologize to you and to Paul if this is well known. For an unaccredited school, does the state bar govern what the requirements are for a student to enter? Do you need a college degree? Do you need a high school diploma to attend an unaccredited law school? And do we play a part in that?
Okay, so there are standard pre-legal requirements that apply to all schools, any of the 3 types in California. So a BA is a possibility, 60 college credits is a possibility, or fewer than 60 with acceptable CLEP, college level examination placement scores, are sufficient. With that said, the preparation could be the same, but each school could have its own admission standards, but same pre-legal.
And do you know, Natalie, do the unaccredited schools, can they take advantage of the GI Bill programs and Golden Ribbon that where departing service men and women can attend school at little or no cost?
In order to do that, the schools must actually meet the ultimate pass rate that is required of ABA schools. So if the school can achieve a 2-year 75% pass rate per class, then they can be waived in and participate in that program. So for example, San Joaquin College of Law applied for that waiver and received it because their pass rate has been at that level for the last couple of years. But generally, it would not be widely available. and I'm not aware of any unaccredited school where that would be available.
Oh. Okay, thanks.
Okay, so just thinking about these buckets of measures, are there any thoughts or comments about possibly bringing back a proposal related to a minimum pass rate? And actually, Cody, if we could go back to the slide with the 4 bullet points. Perfect, thank you. I wonder if there are some thoughts or questions about staff pursuing any one of these 4 buckets to think about bringing a further proposal for you to discuss and also for CS BARS to provide some feedback as well.
Natalie, I have a question.
Sure.
Just from a historical context, you had mentioned that the accredited schools starting back in 2018, we started this MPRE. Was it for the same reasons? Was that the issue back then? And I apologize because I wasn't on the CB back then.
Well, not exactly the same reasons, but it was designed to be, a very clear, very communicative, very easy to administer measure of important outcomes. So, the theory was similar, and it has been successful.
Yes, and then the second question to follow on is that how did we come about with the 5-year back in 2018? If you could share with us if that's possible.
I'm not familiar with all of the context of that. I believe that there was some discussion in terms of the nature of giving enough time so that those who could not only take the exam, but also repeat the exam. And one thing I know to be true is it's a rather complex calculation to allow February scores and 11th exam for certain people, primarily to allow every person included within the calculation to have 2 opportunities to take the bar exam.
The reason why I bring that up is that you had mentioned 2 potential options. One is a 3-year option, one is a 5-year option. And you had mentioned that for the baby bar, you were given 3 opportunities. Does that 3-year option account for those 3 potential exam dates for them to take?
It's actually double because there's 2 exams a year. So in a year and a half, you would have exhausted your time to pass the first year exam and continue on in school. So I noted that too. That's a little bit different. And let me clarify one other thing. We're talking about 2018, but I think the MPR was passed much earlier, probably before 2016. But then there was a legislative change that made it impossible for the schools to give us some of their data, and so we couldn't enforce it for a few years. So it was 2018 when we could actually effectively impose it, but it came about probably 3 or 4 years before that, when the discussions were held at our level, and we decided to have that requirement.
Yeah, so there's a break in the reporting. There was actually one report before the pass rate, the pass list couldn't be distributed, but since 2018, it is continuous. A 3-year was just an idea to get the ball rolling because it is less than the 5 years that the schools have been used to. And it may be that, a 3 opportunity and then as something more flexible over a longer period of time could both be interesting. One, how many pass in that most advantageous time for the student? And then for 2, for those who don't pass in those 3 opportunities, do they persist? Are they able to go on and ultimately seek licensure? So I think both can be interesting.
Natalie, I had a question.
Sure.
First of all, I think this is a great framework for just identifying things and putting some buckets together that we have to think about. So I haven't really thought about this fully, but I just want to react to Paul's comment about collecting economic data. I think that's really, really important because I think it gives a good profile of who is enrolling in the unaccredited. I mean, I think generally we think that there are communities that maybe don't have access or have limited access to law schools, but I think that especially if we tie it to a diversity plan, I think it gives these schools a greater reach in terms of how they're going to recruit for their schools and where they have to go to do that. I know now in the advent of like online stuff, you can kind of apply anywhere, but a lot of these schools are, you know, located in places, if they're brick and mortar, where people have access to it. And so I think diversity plans are good, but I think a lot of the problem with them is they may not be well-defined. I think we were working on that through CalBARS or somewhere, maybe it was in this committee, where we were kind of looking at criteria for these diversity plans, because oftentimes you're so broad, it's sort of like, yeah, look, we need to go more into the African-American community or whatever. And all that takes money. And so having a successful diversity plan also means, I think it's tied to attrition. You know, what can we do once a person's enrolled to get them accustomed to the culture, if you will, of the law school and you know, all the things that perhaps make it easier for people to get through, mentors and things like that, and all of that costs money. So one question is, are the diversity plans particular to each school, and you just say, well, let's have a diversity plan, and they do it, or is there specific criteria that we include that we could say, are these criteria applicable to your school, and then how do you plan to go about funding it? So I don't have all these fully formed, but that's why I appreciate this report, that it defines these buckets that we can start thinking about. But that, for me, that's kind of a good starting point for how to look at diversity planning.
And it is true, and we're really thinking about two things. We've given you've given through the rules some bullet points for them to think about and include in the diversity plans, but you've also left room for them to choose their own metrics that align with their mission. And then from a staff perspective, we're trying to bring you data. So over the last 3 years, we've continued to increase the amount of data that we bring you about 1L, and this year for the first time, you'll be seeing some data on 2L attrition, so just overall numbers. And then also the Access and Inclusion Group did a survey that involved some information about academic support programs. And a couple of years ago at the Law School Assembly, we also talked about the concept of inclusion and belonging. And we brought some programs, one, for example, UC Law SF, the LEAP program, another out of UC Irvine, that talks about what are some of the levers that those schools are using to have a very successful type of retention, persistence, and progression program, and might be time to start to bring those back as these are considered.
Yeah, that's very positive. The other comment I had was, and this is not just an issue, I think, with the bar, but diversity in general. There's a big, the categories are very broad. So you say Asian, that's a lot of different types of people. Some are immigrants, second, third generation. The same thing with Latinos, you know, multiple countries or areas of the U.S., and even African Americans. So I'm just thinking about this. I don't know how that data can be broken down, because it's already very difficult. But, you know, looking at Asian and Latino groups in particular, a lot of times it gets really stereotyped into, you know, this is all Asian, but there might be more, say, Chinese than other groups. And so what does that mean in terms of how do you do your outreach, and how do you prepare yourselves for doing that kind of outreach and retaining students as well?
Well, and another factor that we think about here is also when you're thinking about the pipeline, in which direction are you looking? So the Department of Education tracks their data through iPads with a certain categorical breakdown. The ABA uses a categorical breakdown. The State Bar, in terms of looking at the attorney population, if you're pushing forward into licensure, uses a slightly different one. And so thinking about the direction that's most impactful so that the school can have the fewest number of categories and most time focused on education can be really challenging. It's a good point.
Yeah, no, I get it. It's not something that you can just say, do this. I mean, there's a lot into it, but I'm just kind of thinking of all the different angles that may help. So again, I appreciate that the report came out and it's kind of put into very, you know, succinct categories that we can start to think about it.
Mm-hmm.
Vince, I'll make one observation regarding the connection of diversity plans to part of the issues we've identified in the study. In one way, it's not really connected. There is a diversity issue about the diversity of the law school classes. But as far as academic success goes, I don't know that it has a lot to do with that. And I'll just observe, when Alan and I were talking with Natalie at a meeting to prepare for the discussion of this presentation, we went and looked at the rule that requires a diversity plan, and it says very little about academic support. And so I think I'm just going to observe that that's a place maybe where we could also improve our regulation of the schools and then our scrutiny of their work. Now, basically, the rules say that they have to provide a sound educational program. That's almost a biblical term. You know, you can read into that whatever you want, but it's not very precise or directive, and that may be another place where we want to look to improve our standards for the schools.
Thanks, Paul.
Any other questions?
I don't have a question. I just was going to note that before 2019, the ABA had the 5-year 75% pass rate, but after 2019, they changed the compliance standard to be 75% of the graduates have to pass the bar within 2 years of graduation. So that was a somewhat recent change, but I imagine the old standard was perhaps why we set a similar 5-year.
Yeah, that's a pretty good guess. Thanks.
Question. Boy, I was looking in my inbox. I was searching all my histories about the NPR. I mean, it goes way back in 2018 when I had a conversation with Natalie about how the numbers were calculated. It's overly complex. It was sophisticated, where I thought I was a mathematician, but I couldn't even get the numbers correct. But that being said, all the members are coming back. The question I have is what are the primary benefits for law school students to pursue an education through an accredited law school that they cannot get through the accredited law schools? Other than cost, obviously, there's a lot of cost savings. We already saw a slide about, how little they're paying compared to CALs and versus ABA law schools. But are there any realistic, concrete benefits that they can get? I mean, I'm only asking because I'm thinking, looking at the options for future investigation and discussion, a lot of these will spell trouble for the current accredited schools, just because, one, they're hand-tied because they don't have the financial resources. They may not have the human capital to pursue or to comply with whatever that we decided to do here, including setting the minimum NPR, whatever it may be. So it could spell the end, potentially, the end of an accredited law schools if they can't comply with whatever we decide to do here. So I'm just thinking long-term, in terms of my long-term thinking, other than cost, can they get the same benefits from CALs if they can't get the same thing from non-CALs?
Well, that's a really good question. And I'm going to ask Cody to go forward one more slide and say that I want to take every question that the committee may have before we proceed. But the very next thing that I want to discuss is, we want to go to there we go, is should there be a supportive mandatory pathway to accreditation for unaccredited law schools, and what could that look like? Because we really do see a lot of changes, and I'll be discussing a little bit more specifically what those are, and the benefit, the positioning and the benefit of that group of schools has changed. The commitment is there. We saw that this morning with Dean Leal's school, but the market situation is different. So I'd first like to see if there are any other questions, and if not, I'll proceed with this part of the presentation.
Well, let's go back to another element of this question, which is why would an accredited law school appear to be more attractive to a student over an unaccredited law school? I can think of maybe two things. One is very economic, possible access to federally guaranteed student loans, which probably, I don't know if there's an unaccredited school that could possibly get there, but, and then second would be, well, you've got a demonstrated track record of better bar passage, which implies that the quality of the education is somewhat better. Although, you know, I mean, they could also be the relative abilities of the students that go to the particular schools. It's hard to be sure what's going on there, but those are the two I can think of.
Is there also access to other states, taking the bar exam in other states? I know
That's
ABA accreditation is generally required.
right. That door is kind of creaking open a little bit, but we still require both the accredited and unaccredited law schools to warn people that it's not very likely that they're going to be able to take the bar in any other state or jurisdiction.
The other thing we let them know is that the state of California doesn't control what other states do. So it might, for example, have a pilot program or something in place for a long time that could change.
Any other questions before Natalie goes forward with the
Yeah, if I may.
TNM?
So thank you for answering that. I really appreciate kind of the way we broke this down. I kind of am trying to not worry, understand better, like what are the capacities that we have to partner with the law schools to kind of improve some of these conditions? Because a lot of this is really thinking about my area is about lack of access, right? And I know there's an opportunity for distance learning, but even the distance learning, if you're low socioeconomic status, doesn't matter because you're in a low socioeconomic status. So if you don't have the resources, you can't pursue this kind of career. So what capacity do we have to improve those conditions? Because kind of how I'm looking at it is that the systemic conditions are not improving overall statewide. People are, you know, in worse financial conditions. Inflation's at where it's at. So when people are making decisions, we're seeing people are not going to school in general. Like we're seeing a decrease even in regular schools, right? To get their BAs. So I guess how do we as an organization have capacity to affect that? It's very complex. I know it, but I'm trying to just put those nuggets out there because I'm seeing this everywhere. It's not just in the law world. It's in, you know, K-12. It's in the higher education space.
Well, if this issue were easy to solve, many people would have wanted to do so immediately.
Yeah.
We do see the State Bar taking a holistic approach, but more ideas and more funding are always welcome. And that's how you see some of the things like the Justice Gap survey that Access and Inclusion put together. What happens that causes a person who came to law school with the intent to pursue a public interest career, but life changes in the meantime? You know, what are those changes? What kind of academic support programs are available? The Bar Strategies and Stories program that this body supports was incubated in the Council on Access and Fairness. I think it's a good idea to realize that this is a larger problem, and also it's one that is on the State Bar's radar.
So I guess is the State Bar collectively doing like a 5-year strategy plan, or what is the big long-term goal? Because I think the situation we're in is going to be a generational one. It's going from my generation, millennials, to Gen Z, and Gen Z not seeing the value in in an education overall. So what are we doing to be more to address that from the next generation?
Well, one possibility might be to talk about the pipeline program that is separate from the State Bar, but provides a means for those that start in community college to think about, consider, and then ultimately achieve not only a 4-year degree, but eventually law school as well. Maybe we want to be looking at those types of programs and keeping you abreast of them and thinking about what else should be innovated and should exist.
Okay, awesome. Thank you.
Anyone else?
I was just going to say, on that, I do know another judge, I think it's in Orange County, who has a program, created a high school program for kids, underrepresented kids interested in the law, and they have this whole thing tailored to try to get them to go to law school. So I think seeing if those programs are out there would be helpful, and you know, how many are there, if any, additional.
Yeah, and the BAR's pipeline program originally was going to start at, I think, elementary school, maybe at least junior high, but it's been moved further down the pipeline to the community colleges, apparently. But it does seem that you have to, this is a long process, and you can't change somebody when they're in college, change their approach to education. It needs to start early in life, the drive to make it all the way to the end.
Well, and there may be also some very non-obvious solutions. So, for example, a new change that the State Bar is making for those that will report their continuing education, starting with the next cycle, is that now you can claim some credit for participation in mock trial and moot court. And so having more attorneys have more incentive to participate in programs like that. There's the student that's always planned to do it, and then there's the person that says, hey, I'm going, why don't you come along? And then they're energized to pursue a legal career. So you might not have thought of MCLE for attorneys as a connection, but it could be a spark. And so we should be wide-reaching, we should be creative.
And I think one other one that we haven't, I think, fully considered is the bar committees. Like, not our bar committee, but the ones that are within, like, the LA County Bar or the Santa Clara Bar. Here, the LA County Bar has a high school program where attorneys meet with high school students to kind of talk about the profession and set up what their goals look like. And I think that's an excellent idea, because then it's kind of working through the LA County Bar. They have incentive through this MCLE program, and they're already doing programs like this because they've already identified it as a point of importance. That's also an idea.
So Natalie alluded to this, and I just want to be clear that that this is a subject that is that takes a lot of energy and focus of the State Bar's Council on Access and Fairness, where they look at pipeline. They in fact incubated the high school law academies, which is the sort of program that goes from high school to community college to get the 4-year degree to law school. They are looking at, how to, innovative ways to show people. Bet you didn't know that this was something that being a lawyer means. You could do this as a lawyer, right? And videos with the, general counsel of the Golden State Warriors showing like the various types of legal jobs that are out there. And so that is the work that is happening, sort of whether actually in sort of the county bar associations, the work that the Council on Access and Fairness is doing. They're doing some of that in partnership with some of the affinity organizations. And so that's all work that's happening outside of this committee that obviously needs to continue. Ultimately, I know we do have a concern of one of the things that we're looking at is protecting sort of the consumer who is going to law school and making sure that when they are putting their money down for law school, ultimately they have a chance of getting to the end result that they're looking for, which is, for the vast majority of people who are applying to law school, it is to get admitted to the bar. And so while we're trying to develop these pipeline programs and make sure that people are seeing law as a possible career for themselves and something that they can attain and they can go for, we also, I think this committee's focus really needs to be on, are we providing an avenue that will get them to that goal, or are they spending money, paying tuition, much lower tuition, but paying tuition at a place that's ultimately not going to get them the law degree that they're seeking?
I still see that as an open question. Who are we trying to protect? Of course, we're protecting the public from incompetent, unethical, rapacious lawyers. But also, as far as law students go, is it for us to decide that their dream is unfulfillable and they shouldn't be allowed to attempt it? Or is it our role simply to make sure that they make that decision to have the dream, knowing all the risks and making a conscious decision to assume those risks? We always talk around that, but to me, that's one of the fundamental questions we need to ask ourselves.
I totally agree with you. That is an open question, right? Is it paternalistic? If we provide all the disclosure, we require the schools to provide all of the disclosures, then let the students decide, right? That is absolutely one approach to that. And so, yeah, that is certainly a question for this committee to grapple with.
But I think as a public policy, the committee certainly has the responsibility to weed out what I would call the predatory law schools. And they very much exist. For the past year or two, we have seen quite a lot of unaccredited law schools shutting down, leaving students little in a hole. And so we will be scrambling, trying to protect not just the public, but also these students from being harmed further. I mean, how many times have we seen schools like this for the past 2 years? Quite a few, actually.
Yeah, no,
And-
that's the other side of the coin for sure.
Right, but I think as a matter, like I said, as a matter of public policy, setting aside that fundamental issue about whether it is our duty to protect the students, but certainly I don't think anyone would dispute that it is our responsibility within the scope of this committee to weed out these predatory law schools from being overly complacent, from not meeting the standards that we set for them, right? And as a matter of fact, these unaccredited law schools have dragged down the passage rate to a point where almost feel like the nation is against us because it feels like the bar exam is so hard to pass, not understanding we actually have a different demographics of students taking the bar exam like these ones, attending these law schools, that are actually not being able to pass the exam because their education standard is so low. And we don't have a standard for them. So I think that's where the issue is, and certainly I agree the State Bar needs to address that, and this is sort of the first step in the right direction.
Yeah, we should not have a needle point on our website that says you can be anything you want to be, because that's not quite true.
I agree. But very much, I agree with Kareem. We certainly need to be mindful of accessibility, right? Making sure that we have enough law schools to provide access to anyone who wants to go to law school. But at the same time, we want to make sure they're not diving into a school where they thought they would be getting something valuable, but after paying tuition, they found out they're not getting anything of value. I think that's really the protection that we're thinking about here.
So then what are the measures we can use to make sure, or as best we can assure that a law school is doing a good job of educating its students for success? In the case of the accrediteds, that's been our MPR, 40%. So that's kind of arguing in favor of having something similar for the registered schools, or kind of moving them all into the accredited bucket, or ceasing to exist.
Paul, I just wanted to remind the group that we do have a measure for registered schools, and that is the first-year law student exam. And what I mean is that exam, if you recall when we completed that report and presented on this, is an indicator of how somebody relates to the bar exam. That is, people who are successful on that first-year law student exam, it's a measure of how successful they will be at sitting and passing the California bar exam. And so, we bring the results here after every exam, and our pass rates have been very low. So I just want to highlight that you're looking for a measure of how the registered law schools are doing and its relation to the bar exam. And I think that's another objective measure that also highlights the trend that the pass rate on that exam has been declining.
No, and that's a good point. It does tell the students that, hey, maybe you don't belong here, or you shouldn't go any further, or you can't go any further. But it does subject them to the expenses and the time invested in a first year. And because we don't have a minimum, maybe adding a minimum pass rate for the first year exam would then tell the prospective students that, how they're likely to do, or of course everyone thinks they're above average and that, I'm gonna beat the odds, but it'll tell them about how well the school is doing in educating its first year students. and would allow us to remove from the market those, who fail our standard.
Have we measured the pass rate for registered schools? What is it?
It was in one of those charts in the report. It's, I was surprised that the pass rate for registered schools was not as vastly lower than the accredited schools as I had expected it to be.
Yeah, the most recent pass rate, I think, was 13%, I think, for the last exam.
So Paul, part of the reason for that might be that for the accredited schools, those students generally don't have to take the first year exam. So if they're taking so, they've generally either been academically dismissed after their first year, or they're coming in with less than 60 college credits and instead those college level exam placement courses, or they have been disciplined or otherwise academically dismissed. So it's a different population and composition from the accredited schools that's taking that exam, whereas everyone at an unaccredited would take it.
Oh, I was speaking to bar pass rates, but, and so, yeah, in order to be able to take the bar, you have to have passed the first year exam.
I think another thing that you'll see is extremely high and increasing attrition at the unaccredited law schools. So by the time they get to that point where they're taking the bar exam, it's a very tiny percentage versus the size of the class that began their study. And as a point of comparison, in the ABA, if an ABA-approved school has attrition of 20% or more for several years, that actually becomes a compliance issue for the school. The ABA looks to see that those admitted are carefully matched with the resources of the school that are available and that they can persist.
And that's the one thing that's not on the list here is attrition rates. I wonder if that's another tool to be considered.
Potentially, yes.
Okay, so Natalie's going to go forward in the presentation and take us to a decision point, which is, do we want to leave things as they are or start to investigate the toolboxes and see which, if any of them, might be something we want to adopt at a future time. But we're not making any decisions today. Unless, of course, we say everything's fine, leave it. Otherwise, we'd be going forward with and coming back with some proposals for, with more opportunity for discussion. So it's really what we're asking for today is a sense of the committee. Do you want to look further into this or not?
Mm-hmm. Sure. So let's just talk about a little bit of background that could make this the right time for a mandatory pathway to accreditation. So let's advance to the next slide. So in the past, the unaccredited category had some unique advantages that are no longer unique to that category. So previous to 2020, the unaccredited category was the only category that could offer a fully online program. It also had exclusively part-time programs. There were accredited part-time programs as well, but there was an accredited focus on the full-time in addition. So they had that unique distance positioning. But what we see now is that almost every accredited program has not only a fixed facility program, they may not even have that any longer. They may be totally distance, or accredited schools can mix their modalities, so they also have hybrid programs. We're also seeing extremely fast change in the ABA world, that much faster than any other initiative that I can recall. So back in November, you saw in today's consent agenda, the ABA posted for public comment some adjustment rules to support their current situation in which every school that is ABA approved can offer without a substantive change up to 50% of their JD program online. And just yesterday, the council posted for public comment another proposal that would for the first time allow
distance-only accredited programs to be approved. So previously, the school needed to be an ABA-approved school, which meant it had a physical fixed facility program, but it could also offer distance programs. If these rules are received positively and ultimately adopted by the ABA, it'll be the first time that a fully online law school with no physical law school presence other than their administrative headquarters will be allowed. And for the November program, we saw a lot of public comment from a school that is accredited by this committee, Purdue Global Law School, previously Concord Law School. They changed their name back in November. So we could presage that that means potentially that school is interested, when it's possible, to seek ABA accreditation. So we're seeing a lot of movement in this area as a result, because there are more choices. You're also going to see at least 2, Southwestern and Santa Clara, offer new hybrid programs this year here in California in the ABA space. Okay, next slide. The other thing too is just that part-time distance is now widely available and widely accepted in every category. And we think that the experience during the pandemic greatly hastened not only the availability, but also the acceptance and the technology to make these types of programs high quality. Next slide. And so Dr. Chavez talked about the number of unaccredited schools decreasing, and you'll see a number up there that's different. So in 2024, as compared to last year, Dr. Chavez reported 12 schools. If we include Irvine from today, we see 10 accredited schools, so unaccredited. So in this period of time, just between introducing that report late last year and now, we see 2 more closures. And it doesn't necessarily mean that there is a problem at the school. You heard today from Irvine, that is a school that cares deeply about its students. When it made its closure decision, it heavily supported the students, but it was not the market choice for the school going forward. So really part of this is also just planning for the reality of a real shrinking in this category. We don't have, we have some preliminary data about how the unaccredited schools may think about something like this. First of all, how many students are affected? About 627 in Dr. Chavez's report. We see under 600 if we look at the more recent numbers from the 2023 annual report. Very informally, at least 8 of 10 of the unaccredited schools have at least inquired as to the requirements to become accredited. We don't have any pending applications for accreditation right now, but there is definitely some interest. And in terms of preparation for accreditation, we can think about, as we inspect schools this year, not only compliance with the unaccredited rules, but also what changes would need to be made, if any, to meet the accredited standards, or maybe they're also already on their way. So there can be a very supportive element to this proposal. Also for the committee, you want to think about where you invest your time, where you invest your funds. So at this point, the money that you're spending across these 10 schools is producing about 70 degrees, about 37 degrees for people of color. And if those same funds were invested in a different initiative or consolidated under one class of schools, the accredited schools, would the impact be greater? And then finally, we can analyze the rule and statutory changes that might be needed if you wanted to go forward. Thanks. So thinking about next steps, I'm going to turn it over to Paul.
Okay. So as I said a few moments ago, one is to continue the status quo, do nothing. Other tools that we could consider are minimum pass rates for the unaccredited schools. That could either be the first-year law students exam and the bar, or one of those. And moving some of the other requirements that we currently apply to accredited schools, apply those as well to the unaccredited schools as part of the process of reviewing the rules that apply to them that we have underway anyway. And the third alternative would be to work on mandatory accreditation for schools, for the registered unaccredited schools. And historically, I had forgotten about it, but I guess shortly after I came onto the committee in 2017, this committee had actually proposed, we had a proposal that we forwarded to the Board of Trustees to work towards mandatory accreditation. And I believe, Donna, is your historical memory active? And that the board blessed it, but it, what do we say, died in the legislature because registered schools are, I'm giving Donna a chance to
Swallow.
chew. Registered schools are provided for by statute, so, you know, we need the legislature to change the law before we could implement much of this. We could probably, well, I'm not sure, but we might be able to do things like minimum pass rates and things like that, but to completely eliminate them, I think would require legislative change. So, Donna, I think you were around then, and you took this to the legislature, and how did you do?
I was. So I was and I did. We had preliminary conversations with legislative staff at the time. But what we weren't armed with was some of the data that Dr. Chavez presented earlier. And there was at that time, right, we didn't have accredited schools being able to offer distance learning programs. They were only fixed facility programs at that time. And so there really were still opportunities that only existed in the unaccredited school environment. And as legislators obviously concerned about, as we hear from Kareem a lot, right, the folks in their community who who had no access to a fixed facility school, wanting to give them an opportunity. I think certainly anything that we do in this sphere, we would absolutely be talking to the legislature. We would need statutory change. We'd want to make sure that folks were on board with this. But we are in a different situation now because we do have the accredited schools being able to provide distance learning education. And I think sort of some of the data that just looking around the room that some of you are responding to, I think also, you know, others would respond to, and we can have a more informed conversation at this point. But we would absolutely revisit with the legislature if, depending on whichever direction the committee is interested in.
And Paul, another very helpful fact is that for those distance schools that became accredited, they kept their modest cost profile. So the committee doesn't have control over what the school charges, but they remain modest even now 3 years into a distance situation. So that's another plus that we've seen in the marketplace.
Yeah, thanks. I was going to ask Donna how important the economics are to the legislators, you know, the cost. And you're suggesting that we don't need to expect that the costs will uniformly rise if they became accredited.
Yeah, and I obviously can't answer the question for all. I think to the same extent that you all have concerns about the economics of it, legislators would naturally have the same concerns. And so, you know, I think the question really is, what opportunities are being provided for people across the state of California to get access to a legal education, but a legal education that is going to result in the outcome that they are paying for, right? The reason that they're going to law school. And so, you know, I think that we just need to, again, have a data-informed discussion about it.
Okay.
I have a question. Is there any precedent for, basically you have an unaccredited school and they want to become accredited, and so we have all these standards and they go through a process and we say, oops, sorry, you don't meet the standards. Does that mean we put them out of business? Can we do that?
Well, under the current rules, they could continue as a unaccredited school.
Right, but if we implemented the thing of you got to be accredited or nothing,
can have-
There'd be a phase-in period, so I think it was rather generous, if I recall, it was like 5 years or something. Might have been longer, on the 2017 proposal. Yeah, I mean, it's up to us to design that, but I think the ultimate goal is that at some point, say 10 years from or so after we implement it, that there are no more registered schools.
registered schools are subject to some kind of oversight, correct?
Right, they get inspected by us,
Okay.
they have to meet certain standards. Our story would be that the standards for accredited schools are higher, and I believe that's the case. There's certainly more, we're more specific about some things. But we also have going on with the accredited schools this notion of joint accreditation, where they're going to be, they won't be inspected by us on a regular basis, and unless we find that there's some problem that we need to look into, because we're presuming that the other accrediting agency, whether it's WASC or someone else, is is doing an adequate job of making sure they're towing the appropriate lines.
And also, I was just talking to Donna about this. I was trying to gauge the California bar exam passage rate for these unaccredited law schools. And if you look at the last one, everything's blocked out. I have no clue, because they have so low in terms of the number of students taking the bar exam. And so they're not, they're within their discretion to disclose that information, but I have no idea how many of the students actually pass the bar exam. And so that's sort of another thing I'm struggling. I have no idea how well these schools are actually doing in terms of this objective metric. But that being said, I certainly see us as an incubator, in the sense that we are incubating, right? It's like very much like a startup, incentivize them to bring themselves into a higher educational standard, right? That's what we do as a committee of bar examiners. Right now, they're not incentivized to do anything other than just enrolling students and hoping that they can teach them and pass the bar, whatever they may be, but there's no consequence in terms of failing the students. And I think that's what I'm very concerned about, is what can we do as a committee to ensure that there is something to incentivize them, but also helping them incubate these startups or law schools that are fairly new to so that they can elevate themselves into the accredited status, which is far more resourceful, right? Because at the end of the day, you don't want a startup to be a startup permanently. They have to, at some point, to grow as a company or as a school, so that we actually see the value in enrolling students at that school. And so anyway, this is just a long-winded way of saying it's a good program. It's something that we need to consider, regardless of what the socioeconomic implication. Obviously, we have to think about that. And also the diversity issue, we have to address that. But don't get distracted that there's a long-term goal here, and maybe we can do both together. There is a possibility we can do both. It's not exclusionary. So with that said, what's the next step? I know there are a couple of options on the table. Is the next step for the staff to propose something at the next meeting, or for us to sort of brainstorm on additional options? What's the next step?
What's the next slide? Show us, Cody.
So the actual motion today will really actually just to receive the law school profile report, but we'd appreciate as staff direction the sorts of things that you want us to research. Are these measures the kind of things that you'll want to see? And we can bring back a more operational plan for a more full discussion, and also feedback from CS bars as well. And I mean, I'm overall sensing yes.
It's probably not realistic to have a complete package ready to adopt at whenever our next meeting is. I don't know if they could even get to it for March, but maybe another way to ask about it is, are there any of these tools that we've discussed today that somebody thinks should not be further researched? And ultimately, I'm envisioning a comparison of the different tools, presented to us, so then we could decide if we want to do any of them, use any of them, or combinations, or what. And then trying to draft language for rules or regulations or statutes before we know what we want to do, I think would be a waste of time. I think we sometimes get into that. I mean, I've certainly seen it at the agencies I've been with, and people are arguing over the structure of a sentence rather than the high concept. So if we could keep it at high concept the next time, but with more details, and maybe with, a summary of the statistics that we've just gone through today that relate to that particular tool, I propose that would be a good way to go forward.
So
Does
Paul,
anybody?
Just to clarify, so you're asking us as a general body not to pick one of those particular four options, but just to move forward with developing the concept? Or are you asking us to pick one of those buckets so that Natalie and staff can kind of focus in on that, just to clarify for everyone?
Well, if everyone's settled on one tool to be looked at, that would be fine. But I suspect we're at a point where we need to hear more about all of them. And it'd be better to just bring back that for discussion. I mean, you're not deciding anything. You're just deciding that you need, more developed information to decide if you ultimately want to do any of these things. And it's just a sense of the committee. The motion is simply, lost it here,
To
receive and file the profile report.
Yeah. Well, I sort of see, I know there are 4 bullet points, but the way I see it is there's only 2 paths going forward. One is to do nothing, keep the status quo, or the second is to develop like a very rough conceptual proposal so that we can talk about the detail and tweak if necessary. So that's the 2 things I see going forward. Because whether we will consider the NPR or adopting other requirements applied to accredited schools or updated proposal, they're really a part of that bucket anyway. So anyway, unless just someone sort of sees or have a strong view about not moving forward, then I think it makes sense for the staff and Natalie to go ahead and try to come up with something for us to talk about again. Again, this is a marathon. It's not something we can adopt at the next meeting, but we certainly need something on the table to discuss something more concrete. But I think conceptually, it sounds like we're in agreement. I don't want to speak on behalf of anyone, but unless someone speak up now, it sounds like it's something to pursue.
And this is something Alan and I, as the subcommittee chair and vice chair, would work on with staff to iron out something that comes back to you that's it has all the information you need and is presented in a way that we can effectively discuss it.
So I'd like to, because this is I think a very large undertaking for the working group, Paul and Alan, as well as Natalie and the staff. And I think it'd be nice to hear direction. So normally I don't do this, but I'm going to call on each person so that we can kind of get a consensus on what the general body wants to do. Kareem, what are your thoughts?
Yeah, I would be in agreement. I was in consideration this to be a work group or committee. I mean, this is a 5-10 year approach that you're looking to affect. There won't be any immediate results depending on what strategies or approaches we take, but I see this taking place over the next decade. Like this, what we decide today will have a big implication. So yeah, I'm in favor of moving forward.
Yeah, I pretty much agree with him.
Okay. Dr. Bolton? Great. Justice Masiwala?
I agree. I just want to add that to me, I think one of the most important parts of the discussion was about whether or not, I understand there's maybe less than 10 schools that are unaccredited now, and whether or not to require them to move to accredited status. And my concern with that is the cost to the student. So definitely I'm in favor of exploring these opportunities, but to me, one of the most important aspects of it would be the cost to the student who is enrolling in those unaccredited schools, and whether the cost would significantly increase.
Robbie?
Yeah, You know, I think this was,
Robbie, can you turn your mic?
I'm sorry. I think this was a great presentation and discussion, very sobering information. So I'm all for moving forward, exploring, you know, as you say, all the possible ways to make some improvements for the students.
Bethany?
Yeah, I just want to clarify, when we say moving forward, are we talking about setting up a working group or?
That is whatever you think, Bethany. That's what, I just want to make sure we get our entire input of the entire body so we can give direction how to move forward.
Okay. All right, well then, I will state that I do think that a working group is an appropriate and a useful way to continue these efforts.
Vince?
I'm in general agreement. I don't think we have to wait for an entire package before this body adopts something. There might be certain tools that can get adopted ahead of time. So I think a working group would be helpful to look at sort of long-range and short-range goals.
Ashley?
I'm in agreement with everything that's just been said. I don't really have anything else to add, but I think a working group would be really helpful.
Jim?
So as I see the four options, the only one I would disagree with, continuing the status quo. I think the change is required.
Judge Reyna?
I agree with what people have said. In looking at the slide, the three last bullet points, I agree is something we should look into and get going to try to bring us more information to see where we can go forward.
Alan?
Well, we're definitely going to move forward. I would like to also think of ways that we can either mandate or encourage these schools for they need academic support for some of the students that are admitted. And that's something else that we have to consider so that these students who are admitted spend all this money, they have the best option to succeed.
Alex Lawrence?
I agree with what's been said to move forward with a working group. Bethany and Ashley, their comments, and others. So,
Esther Lynn? Vice Chair Alex Chan?
When you have Alan and Paul in the working group, that's it. That answers it.
All right, sounds like a consensus that there's going to be a working group. And what are your thoughts, Paul? Because you've been intimately involved in this.
Well, you know, I agree. I've been for a couple of years now saying we needed to address the question. You know, we've had on our working plan, consider mandatory accreditation, and we never talk about it. And so you have made me happy in that regard. And I'll just note that we need the motion to receive and file.
Before we make the motion, to make Paul happy, that's a big deal.
I'll make a motion to receive and file the report.
I'll second that motion. It's Vince.
All right, Devin, may we get a roll call vote?
Dr. Bolton?
Yes.
Robert Brody?
Yes.
Alex Chan?
Yes.
Jim Efting?
Yes.
Kareem Gangora? Paul Kramer?
Yes.
Larry Kaplan? Alex Lawrence?
yes.
Esther Lynn? Justice Macy Walla? Bethany Peak?
Yes.
Ashley Silva Guzman?
Yes.
Judge Reyna? Vince Reyes?
Yes.
Alan Yokelson? Dr. Cow?
Yes.
With 14 yeses and 0 nos, the motion passes.
All right, thank you, Devin. At this time, I'd like to see if we would be able to take a break for about 10 minutes, and then we can all reconvene. Thank you. Number 5, moral character. The action on revisions to the moral character rules, recommendations to circulate revised rules for public comment. I'll turn it over to Tara, David, and Bethany.
Alrighty, thank you, Dr. Cow. So we're gonna set the stage. I don't think you could hear me again, sorry. I know, and they're very tall. Okay, so thank you, everybody, again. So these are the moral character rules. So as a reminder, again, these also came before you in March of last year. And then the rules went to the Supreme Court. They did deny the changes. There were some consistency issues. We didn't use the term, for example, receipt, which is defined in Rule 4.3 throughout, and a couple other minor changes that we did make. In addition, if you do recall, there was a change we had to Rule 4.41 that we were circulating separately. That came before you in August of last year. Since we received the court's rejection of the overall rule changes prior to the changes to 4.41 going to the board, we actually ended up rolling them into these changes. So now we're presenting you with one set of rules regarding moral character. So the biggest things we went through, and we tried to make it very consistent using the terms which are defined. In this case, it was really just receipt. We removed the reference to the out-of-state attorneys who are not in good standing or disbarred from Rule 4.41. We also amended a timeline, or added a timeline for an applicant whose positive moral character determination has been suspended. The rules as they currently stand, they referred back to the normal processing times, but it didn't quite fit properly. So now we've just added in, kind of mirrored the timeline that is earlier, but giving them notification of when they will either get questions from us regarding the reason for the suspension or the positive will be reinstated. And then finally, so the final two rules, the positive moral character determination is valid for 36 months as stated in the rules currently. However, in practice, once an applicant submits an extension application, that positive determination is essentially told. So they can't use that while the extension application is processing to get on the motion to make sure there's nothing that we need to look into, ask them about further. So we clarified Rule 4.41 to add that in to make it just explicitly clear for applicants, and then mirrored essentially the changes to 4.52 to make it very clear that that positive will be reinstated if it's granted again at the time that the determination is given again versus some other time in the process. Now, that was a quick overview, but all the other changes have come before you previously, so we just wanted to highlight those specifically. David, Bethany, or Vince, did you have anything before we take, or?
No, I just wanted to add that a lot of the revisions were to help bring the rules in line with how it actually works for the staff. And so I do think that it's very streamlined, and I know that this has been a number of months' work. And so thanks to the staff for taking care of all that. Vince?
Yeah, these are so complicated and sometimes confusing, and I'm guilty of what Paul said earlier. Sometimes I'm arguing with myself around sentence structure and missing missing how do you clarify these rules. So, I appreciate it also, echo Bethany's appreciation of the staff.
Thank you. And I think, Paul, did you have a question for us or comment?
Plural.
Okay.
Just a warning.
Should I bring up the rules?
On page 15 of the staff report, that's the actual language. Hold on.
4.43.
4.42. There's a kind of one of those sentences I'm going to not pick on that one, but the sentence in the middle of that paragraph is one I think that probably causes Vince's brain to hurt a little bit. It could be rewritten, to be clear. My first substantive comment is about, let's see, 4.44, which is on page 16. And it says an applicant may withdraw its application for moral character anytime before, oh wait, maybe I misread that. Anyway, I thought it was, so they can only withdraw it before the state makes a determination. Or actually it says before the state tells it that it's unable to make a determination without further inquiry and analysis. Why shouldn't they be able to withdraw it at any point in the process? Because then they come out without a determination. And it says here we keep the money, so it's no skin off our wallet.
Well, for example, not close enough again. For example, if somebody is engaging in UPL, unauthorized practice of law, even if they do withdraw it, that we may make a referral to OCTC for the public protection aspect. That's the example that comes to the top of my mind. I don't know, David or Christian, if you have
Okay,
any
but
other-
that's not prevented by letting them withdraw.
No, so they can't withdraw once we've asked for further information. So we may get an application, we discover some potential misconduct going on that the applicant's engaged in, like UPL. We ask them about it, and they say, oh, I want to withdraw my application. And in that case, we may not allow them to withdraw their application because we may want to, first of all, they may receive a adverse determination. And we don't want to foreclose the possibility of being able to take action like referring a UPL case to OCTC, for example.
But you don't need a moral character application to refer to OCTC, do you?
No, that was a bad example.
I was just thinking when we do the moral character, there are a lot of people, not UPL, but other misconduct that they might engage in, and then they attempt to withdraw their application so that when they reapply at some other stage, they can say that they did not, receive an adverse determination. I think that's what the rule is trying to prohibit or prevent.
Well, but it says in here the bar may retain the application and presumably all the information you've developed as part of their file.
But if they go to another jurisdiction, they would be able to say that, no, I just withdrew, and then the other jurisdiction may not contact us, they may not know. It's more of a preventative rule.
Okay, it sounds like a bit extortionistic to me, but I'll go ahead, I'll accept that. And then my next question is on, let's see, 4.45. Compare 4.45A and B. B lists 4 reasons or 4 things that the bar could notify the applicant of, and 3 and 4. But A only lists the first 2, but it seems to me 3 and 4 are also applicable to A.
So in the process, once it's submitted, then we have our folks in our pre-processing unit, they'll go through to make sure we have the minimum information and documentation, and that's when they deem it complete. And so at that point, either they're going to go ahead and issue a positive, they'll refer it potentially for a question and ask for more, but at that point right there, they're not going to be invited to an informal or offered an agreement of abeyance without some sort of further inquiry.
Okay. Yeah, that assignment of responsibility among the units isn't really revealed in the language here, but okay, I understand that. Then in 4.46, it says the committee is going to establish procedures for an informal conference. Where are those going to be memorialized, in guidelines or something like that?
So these are the procedures that you already have and that you've already approved. They're up on the State Bar website for applicants. We also link directly to it when they invite them to an informal. We were just trying to clean this rule up a little bit because it mentioned the procedures, but then some of the things contained in the procedures, but not everything. So it was more so trying to mirror the important facets from the procedures that already exist.
Okay, so they're available for somebody to easily find if they're trying to fully understand our system. A final, well, I'm not going to say final, but 4.46.1B says, right before the struck out text, it says the State Bar must notify the applicant of the committee's decision within 10 days of the decision. I would propose that we change that to shall. Must has the hint of if we fail to do so, then we are somehow penalized for that behavior. Shall is just a mandate. I think shall is a better regulatory language there.
Can we look at that as part of the sort of grammatical changes after the fact? Because I think the State Bar's convention is must, but we'll take a look and make
Oh,
sure.
okay. Wow.
Yeah, that's set forth in Division 3 of Title I. Must is mandatory, may is permissive, et cetera.
Shall is just not used. Okay, it's different than my experience, but okay, And, okay, maybe finally, in 4.49, on the last line, it says, or last two lines, it talks about the time when an applicant can file a new application following an adverse determination. And it says, basically it sets a default of 2 years from the final determination or such other time set by the state bar or the committee. And then there's the phrase for good cause shown. I'm wondering what that's adding to the equation. It's not new words, but is it implying that the committee has to make a finding of good cause in order to change the length of the time which they have to wait to file another application? Or is it meant to tell the applicant that they have to show good cause, which I don't think is appropriately placed here, because this isn't talking about the applicant's burden to try to reduce the time. I would just delete the phrase, frankly. I don't know what it adds.
Yeah, I mean, I think the phrase could probably be deleted. I think what it's intended to mean, it's putting a fine point on the fact that 2 years is the default, and unless good cause has been shown, without placing that burden on anyone in particular, then 2 years is what it's going to be.
Okay, I just think it may cause confusion more than it really adds anything to it. And then, so as to the point you mentioned, Tara, the idea that when you file for an extension of your determination, it goes into limbo while that's being considered. What's the justification for that? Why, I just don't see why somebody shouldn't be able to ride out the 36 months, because we're kind of encouraging, well, we're encouraging people to make some kind of guesstimate about when they're going to be able to be sworn in otherwise. And, people who are prudent, they can file it up to 6 months ahead of the 36 months, would probably do it then just to make sure that there's no gap on the other end. But on the other hand, we're creating a gap because we're saying as soon as you file that, then your determination is on hold. What's the rationale for doing that?
So if the applicant discloses the extension application, it's called the extension application, but really what it is it gives the applicant the ability to not have to redisclose their whole history, just what's happened since the last determination, as well as it's half the cost. So we are actually looking at if there's anything new in the application. So if there is something that we need to look at, investigate further, we don't want them to have the ability to go ahead, get sworn in. Regarding I think the time frame, this is in practice how it has worked, and that's not the best reason, but we can't have somebody who potentially there's something we're looking into and then they get sworn in. The alternative would be not to offer an extension application and make them redo it every 3 years, but at that point, that seems like too onerous of a burden to place on the applicants.
Well, another alternative would be simply to let them apply, and if they're ready to be sworn in at the end of the original 36 months or an extended period, then they can be sworn in. If they disclose something in the extension application, you have the right under another section to temporarily suspend their positive determination. It just seems to me unreasonably strict to automatically suspend it when you have no reason to think that there's a problem. And originally we did say for 36 months you're good to go.
I don't know if I'm just reiterating what Tara said, but so it is true that if they submit, if they update their application, just forgetting about an extension application for a moment, and it's with adverse determination, we can suspend the positive determination until we have a chance to look into the matter. They have to do that within 30 days of when there has been a change in the information relevant to their moral character application. They could theoretically submit an extension application, a month before their positive determination is going to expire. It could contain adverse information that frankly, it doesn't even get processed to the point where we're made aware of it and are able to take action on it before they get sworn in, before the end of the initial 36-month period. So it's possible somebody could update us with adverse information prior to the end of a positive determination by including it in an extension application, and then the next day go get sworn in while they still have a positive determination. And so this means that right when they extend it, they're sort of putting that positive on hold. It's not terminated, but it's, like you said, they're sort of in a limbo period, and then if we approve the extension application, it's reinstated and then extended.
And I'll say in practice, I mean, most applicants who, if they have the positive determination, they're waiting to pass the bar exam to get on the motion. And so they know if they've taken the last exam, when the results are going to come out. So they wouldn't necessarily, if I took the July exam, my moral character is going to expire in December. I wouldn't necessarily submit the extension application in June, because I think everybody hopes they're going to pass the exam and they'll get on the motion. And then once they're on the motion, that expiration date doesn't matter.
Okay.
What's the rationale behind the 36 months versus, let's say, 60 months?
I don't know is the answer to that. I do know that previously, I don't have the date off the top of my head, but maybe prior to 2010-ish, the positive moral character determination was only good for 2 years. And then at that point, the rules were changed to extend it to 3 years. And this is where we added in this 18-month update letter. So we prompt applicants halfway through to ask them, to make sure we've disclosed anything else. But how the actual 36 months was set, I don't have that history, but I do know it was extended from 2 years previously.
I mean, would it make sense to enlarge or increase this number? And I only say this because if an applicant submits their moral character application, and let's say for the next 3 years, they haven't committed a crime, and so the applicant will remain the same in terms of what they need to report to the state bar, why would we, and at some point, if somehow they do commit a crime, they will have to report to us about, right, any such reporting. And so I'm just trying to understand, why can't we enlarge this number from 36 to 60 months, which is the 5-year period that is allowed under the rule?
One caution would be that even though applicants are required to disclose the updates to us within 30 days, they don't always. And I think one of the only ways that we know if somebody has a positive determination and something adverse were to happen is we do get subsequent arrest notices. But for any other type of misconduct, we might not get that information ever or in a timely manner. So I think that is the concern about extending it that much.
But that's the burden on the applicant for them to be diligent in reporting and updating the committee about things like that, of that nature, right? If somehow, if an applicant comes to us and says, hey, I'm at the last deadline, 60 months, you need to give me a positive ruling on my application, then we can think about whether to extend it to the applicant. But what I'm trying to understand is, why 36 months? Why not give them more time?
I would say, given the suspiciousness that, of applicants that is embodied in this notion that I'm objecting to, excuse me, 36 months seems long for us.
Huh. So you and I are on the different side of that spectrum, huh?
Yeah.
I see.
I don't know. I mean, this is an untrusting provision. And what the downside is that if somebody got sworn in and then revealed to us that they had committed a crime, it would be much more difficult to go through the disciplinary process to relieve them of their right to practice.
Yes.
So is this an administrative convenience argument?
I mean, as well as public protection, because if they do get sworn in and there's information that we don't know, in the meantime, they could be causing harm.
Okay, well, at a minimum, I think you need to say at the end of that sentence, whichever occurs first, to be clear that the submission of the extension application would, if it's earlier than the 36 months, which I think it has to be by definition, would terminate or put the original positive determination on hold. Because that wasn't clear to me, frankly. I wrote a question to myself. Does this mean it was suspended?
You mean, you're talking about 4.52?
4.51.
Oh, because it says a positive moral is valid for 36 months or until submission.
Right. Does 5.2 maybe answer that question?
I was thinking that first sentence of 4.51. I mean,
That's where I mean it should say 36 months or until submission of an application for extension, whichever.
Well,
Yeah.
the application has to
But
be
see,
submitted.
you have two choices, so you need to say it's the earlier of them. You know, that's normal drafting, right? Because we mean the earlier of them in this draconian.
well, we mean if one or the other happens, it ends the validity period. A positive moral character determination is valid for 36 months or until submission of an application for extension of determination of moral character. I guess the idea is that the earlier is implied.
Until, yeah, and best drafted regulations don't regulate by implication. They were clear.
Just say whichever is earlier. Is that what you're suggesting? Whichever is earlier?
That's fine.
Yeah.
Well, as at least being clear about a provision that I think is unreasonably harsh. But maybe that's all I'm going to get.
Are there any other questions, comments?
I'm done.
I just have a question. So the good cause, is that defined anywhere in our rules, anywhere?
It's not, I mean, in practice, it's when, and we're in open session, so, but, you know, when we decide to set the reapply date from the standard 2 years down to maybe 1 year, typically, maybe somebody has engaged in some rehabilitative activities, or like they're on the path, but they're not quite there, but good cause itself is not defined.
Okay. I mean, I know sometimes in laws it's not, but then it's subject to, you know, how a board or whomever interprets it. So I know we've defined, you know, what a conference is, or whatever, informal conference is, and I just didn't know if we wanted to define it at all, but that's my comment. Thanks.
You know, I think the concept is always going to be part of the decision. But my concern is that when we state it here, we're implying perhaps that we have to make findings. And in our cases, we rarely make, in our decisions, our motions, we rarely make factual findings. And so I would hate for somebody to attack, maybe it's unlikely in this context, but to attack our decision because we didn't address the question of good cause that was, called out in the rule.
Well, yeah, but the only time we would do this if we gave somebody less or sooner could apply than before. So I don't see how anybody would say, well, you didn't have good cause for giving me an earlier opportunity to apply.
Yeah.
It wants to be done.
No, it's probably, you're right, in this context, it's, I apply my good drafting principles kind of without context sometimes, and developing good habits is useful. I just don't see it as useful to refer to good cause here. And if we ever put our committee in the business of making formal findings, we are going to find ourselves to be deficient because we just never do that in my experience. So I don't want us to imply that we're going down that road.
And and correct me if I'm wrong, but if an applicant is denied by the committee, they do have the opportunity to appeal to State Bar Court, where they will get a full trial, and then the court will actually make a decision or have an opinion. So I mean, that's going to be the final action of the State Bar if the applicant does choose to go that path.
Right, and if we ever let parties who are aggrieved by the applicants participate in our proceedings, they might be the kind of people that would say, you should have hit him with 2 years, and you didn't make any findings to support giving him just 1 year, that sort of thing. Maybe it's more a general point. I will let it go, but.
Ashley had a point, but Alan, if yours is on the topic, I could let him go.
No, is the maximum denial for 2 years? Or can we extend it for good cause beyond? We can, right?
Yeah, theoretically, yes. I don't know that I've seen that during
I
my
don't
time, but
recall
it is, as the rules are written, you could do the same, but in practice, typically we don't, but.
If you take out a good cause requirement, if simply at the discretion of the committee, I would think that would be harder to defend in a state bar hearing at the appeal level, because there's no, then it seems entirely just subjective.
Yeah, but we never even state our reasons
No.
in any sort of record that could be reviewed anyway.
The record would stand except for an abuse of discretion. I don't know what the standard would be, if it's rationally related. Yeah.
No,
So,
thank you.
Mr. Chair, having listened to everybody, I still would make the motion to set forth on page 7 if it's time to do that.
I had a late-breaking thought, sorry, Paul. Just back to the 4.51 issue, the submission of an extension application is always earlier because you're required to submit it before the end of the 36 months.
So there's a motion on the floor. Is there a second to Jim's motion?
I'll second this.
Thank you, Robbie. All right.
I just had a question. So with that incident that we were kind of going over where someone is, has the positive moral or positive determination and then jumps over and immediately files and kind of avoids that. Has that happened? Do we have that situation happening frequently or at all?
I'm sure it does. I don't have the number off the top of my head.
Okay.
This is not that it's a good indicator, but it's not something that's been at issue with applicants. I think just having the ability to submit this truncated application with a much lower cost they've seen it as a benefit, so.
Okay, got it. Thank you.
Are there any more questions or comments before we take a roll call vote? Seeing none. Devin?
Dr. Polton? Robert Brody? Alex Chan?
Yes.
Jim Efting?
Yes.
Kareem Gangora?
Yes.
Paul Kramer?
No.
Larry Kaplan? Alex Lawrence? Esther Lynn? Justice Macy Walla? Bethany Peak? Ashley Silva Guzman?
Yes.
Judge Reyna? Vince Reyes?
Yes.
Alan Yokelson? Dr. Cow?
Yes.
With 13 yeses and 1 no, the motion passes.
All right, thank you, Devin. Moving on to our next agenda item number 6, report from the director. I'm going to turn over to you, Audrey.
Perfect. Hopefully everyone's we've had this posted since last Friday, so everyone could see what we were going to talk about under this report. And I'm going to turn it over to Cody here in a second, being responsive to what you asked for the last time we met. We're going to share some more admissions-related metrics with the committee today. So let me go full screen. There it is. Okay, and Cody.
Audrey's absolutely right. We got great feedback from the committee about a desire for additional data.
And I think Natalie's great presentation and Dr. Chavez's presentation showed that there's real eagerness here to have more data presented to the committee to inform decision-making. So we are going to make a concerted effort to do so more consistently. So today's set of graphics and data should be kind of a quick snapshot of some of our main numbers, programs, and kind of a level set as we kick the year off. So the first up, we have the admissions fund budget. This was data presented to the board finance committee in January. This is a comparison of the 2024 budget forecast compared to the 2023 prepared budget as well. So these are not actuals, but they're showing some general trends that I want to highlight here. So most notably, you can see that there's a meaningful increase to revenue, mostly associated with the increased fees that were approved by the board last year. What you also see is an increase in admissions expenses. A lot of that related to the increasing cost of exam administration, and I'll share an update on some of our work related to that shortly. But ultimately, the result of these changes means that what was a $7 million deficit in 2023's budget has been reduced to a $1.8 million deficit for 2024. And if we can move to the next slide.
Question, are there any reserves to cover that deficit?
I believe so, but I do not have that number on hand.
I don't know the exact number either. It was. Yes.
Great. So this next presentation just demonstrates the trend for bar exam applicants for February exams since 2021. And again, I want to be clear about what we're showing here. These are the number of applicants who applied to take the exam. We are comparing those numbers instead of final test taker numbers because, of course, the 2024 exam has yet to be administered. But I do want to draw some attention to some interesting trends. We still see a rise year over year in exam applicants with a 6% increase from 2023's administration to 2024. And interestingly, we see that testing accommodation applicants for at least February bar exam administration has plateaued a bit since 2020, or since between 2021 and 2022. However, I know as our team has been putting together forecasts for July 2024, I think we believe that July's administration will be an increase compared to July 2023's administration. So this could be due to the fact that the February bar exam applicant population are repeat test takers, and there's just some different characteristics of this population compared to those who take the exam in July. And that's actually a great lead into this slide. So what we're seeing here is bar exam applicants, first-time takers in gray, and repeat takers in gray, and the first-time test takers in blue. The trend since 2022 all the way to 2024 is typically what we anticipate to see. What I want to draw attention to is February 2021, which stands as somewhat of an outlier. And I think what we're seeing is that the further we move away from the pandemic era administrations, our data is much more reliable, and it's improving our ability to create forecasts and predict future exam administration. So we're seeing kind of a stabilization in the patterns since that 2021 examination. This slide here is a demonstration of the exam population, the applicant population, between general or non-attorney and attorney applicants. We see that both non-attorney and attorney applicants continue to rise. In fact, the attorney test-taking population is at its highest percentage of the population since the pandemic. And I think that's really interesting because it demonstrates that some of the other updates happening at the state bar haven't had a negative impact on applicant enrollment. So I know we recently increased the fees for applicants, with the attorney fees being the highest increase, and we did not see a detrimental impact on those applicant enrollment for the February bar exam. So we'll continue to monitor that. And lastly, this is just a breakdown of our special programs. And we don't have historic data to compare here, but I wanted to draw attention to the population numbers here. So in the multi-jurisdictional practice program, MJP, which constitutes, or which includes in-house counsel, legal aid, and military spouse attorneys, we see over 2,000 individuals enrolled. And I think that's a strong indicator of our robust and appropriate oversight and consumer protection mission. These are individuals from other jurisdictions who are practicing in California. And so we see, I think this is just a demonstration of how effective our oversight and reach is. And lastly, the PLP program and the Law Office Study Program, meaningful enrollment there as well. And so I know there's been conversations today about how we are preserving different pathways to licensure for different communities. And so seeing these programs still with strong participation, I think demonstrates our success on those fronts as well. Yep.
Does the Law Office Study include the studying under a judge?
I believe so for this data, yes.
Oh, sorry, this is to Amy.
All right, thank you. So I have a reminder and a quick update. So I just want to remind everybody that the February bar exam is scheduled for February 27th and 28th. As you can see here, the exam will be held at 3 standard locations and 6 testing accommodation locations across the state. As of today, we have about 5,100 applicants that have been approved to sit for the exam. There are another 330 that are pending approval to sit for that exam. So they should be approved by the beginning of next month. We are prepared to administer the exam to these applicants. And one piece of information that I want to share that's related to a one-time policy that we've implemented just recently happened. So as a result of public comment that was received at the January 18th Board of Trustees meeting, at that meeting, we heard from applicants about that were negatively affected by the fact that there were no testing locations in either San Diego or Sacramento. In the absence of those locations, they requested that we consider allowing them to get credit for the July exam and to withdraw from the February bar exam. So we are accommodating that request on a one-time basis. So that is applicants that are registered for the February 2024 exam that are residing in either the Sacramento or San Diego area. They have an opportunity to receive credit to take the exam in July, when we will have testing locations in those 2 areas. And so applicants that fall into this category have until February 2nd to notify us and to elect this option. And so we've included that information in our weekly blast. We do email blasts for the 6 weeks leading up to the exam. Today, there's the second blast will be going out, and so we're alerting applicants about this one-time courtesy. We've also emailed about 557 applicants that qualify for this, so we proactively reached out to those that qualify to alert them about this. As of today, we have 49 applicants that have elected this option, so we'll know more by February 2nd. So staff are working with final preparations for that exam and also to ensure that we accommodate these applicants. And like we always do, we encourage the CBE to visit the bar exam sites in action. So as you can see, these are the sites. Anyone that's interested in attending should alert either Audrey or Devin, who will follow up after this meeting about coming to visit one of the bar exam sites.
Thanks, Amy. Any questions? No, we'll follow up after the meeting and get the volunteers who want to go out. Ashley?
So as of now, does it look like we'll have capacity to accommodate all 5,600 or so applicants?
Yes, absolutely.
Okay, thank you.
I think it's back to Cody.
Great. Well, I've got a pretty exciting update. So to provide some context for the newer committee members here, summer of last year, we brought to the committee a menu of options for opportunities to reduce bar exam administration related costs. And some of those options included using state bar office space at no cost, reducing the number of sites, and exploring a one-day remote exam model. And the committee asked that we research and explore this topic. So I'm here to share with you all the findings from that research, and this was presented to the board just a few weeks ago. So as a quick summary, we found that the ExamSoft platform that had been used in pandemic-era administrations really was incompatible with many testing accommodations that we were seeking to be able to deliver in a remote exam setting. There are certain testing accommodations that had proven very challenging in a remote setting in previous experience. We reviewed the record and review proctoring approach that this platform requires and found that it's quite labor intensive, and it remains so. And it represents a large hidden cost that really wasn't helping address the exam administration cost related issues. Most excitingly, we explored new vendors, and there's a suite of promising but untested technologies out there that could provide new approaches to remote exams. And I say promising because these are still options that we anticipate exploring and monitoring in the future, but at this point in time, are untested and have not been used at the scale required for the California bar exam. So we determined that they require further validation, but they're not valid at this time.
Cody, what are the names of these vendors?
Well, there's really several available. We list ExamSoft here as an older technology. Some of the new technologies would be Monitor EDU, for example. But I will say too, there's new players in the industry that are popping up very quickly, and through our exploration, we were introduced to options that we were not aware of even just weeks prior. So it's a little bit of a whack-a-mole as far as identifying the full breadth of vendors that are out there, but there's at least a few, including Monitor EDU, that really seemed interesting as we move forward in our research.
Thank you.
And lastly, we looked at kind of some novel approaches, and one that came to the forefront was in-home proctoring, meaning an individual would proctor the exam in an individual's or an applicant's home if they had a testing accommodation that could not be met by a remote vendor. And the reality of that situation was that it just proved quite risky. And now, actually, lastly, the test center model, which we've heard from public comment is quite appealing, and that is something that we continue to explore. It could not be administered in July due to just capacity and kind of logistical challenges, but something that we're really excited to continue to look at. So with that in mind, what was recommended to the board several weeks ago was pursuing or continuing the reduced number of facilities model that is being used for the February examination, and that was approved. And so what July is going to look like is reducing, most importantly, it's fully in person, and it will be administered at 8 contracted facilities along with several no-charge facilities at the State Bar and Judicial Council. And I think the update that really garnered the most attention was that we were able to secure testing facility locations, large locations in Sacramento and in San Diego. And Amy noted that in response to that and the public comment that we received, there are individuals in those areas who will be able to waive their February bar exam fees and take the exam in July at a location near their own address.
Any, any other questions for Cody? Oh, Donna, this is your update.
Thank you. So just a quick update. As you'll recall, for the past year and a half, we've been discussing increases to the admissions fees. The Board of Trustees adopted most of those fees that we had discussed at their September meeting. Subsequent to that, there were a couple of fees that couldn't quite be implemented yet. Two, the Pro Hoc Vice and the Out-of-State Arbitration Council fees required changes to the rule of court because the cap on that fee was set forth in the rule of court. So we did propose amendments to the rule of court. Those rules of court put it out for public comment. And at the January board meeting, the Board of Trustees approved transmitting those changes to the rules of court to the Supreme Court for adoption. Once those are adopted, the revenue projections from those two fees was fairly significant. And so when we get those adopted, that will also positively impact the admissions fiscal condition. The two other fees that were not approved when we brought this to the board in April dealt with the fees that are charged to the CALs. One that is tied to the submission of the annual report, and the other that relates to the inspections. The board was interested in reducing the increase. There was a significant increase from what is currently charged specifically for the annual report fee in particular. There was a significant increase that had been proposed and that this committee supported in order to address the fiscal condition of the admissions fund. Because the revenue in 2023 that came in was higher than projected, the board was interested in reducing that amount somewhat, so the increase would not be as significant, and also wanted to put out for public comment an approach for providing tiers instead of a single fee for all CALs for the annual report. Looking at tiers based on school size. It was a discussion that we had at the meeting, but since we hadn't previously put that proposal out for public comment, the board wanted to see that go out for public comment. So we did put that out for public comment, along with a recommendation that we not tier the inspection fee because we looked at the data from the last 10 inspections, and the amount of time that was spent on the inspections did not appear to be tied to the size of the school. So tiering that amount didn't seem to make a lot of sense. We put it out for public comment. We got 26 public comments about, we asked for comments on reducing the amount that was proposed by a third and reducing the amount proposed by 2/3. The comments were split down the middle. And then within each, we asked for input on various options for how we would tier it, either very small schools and large schools, or even taking it down to a per student rate, basically, because essentially what we were told by the CALs was that the only way that they could incur this additional cost, they would have to pass it on to the students. And so we looked at an approach that said, here's the total amount of money that we're trying to achieve here. If we divided that by overall student enrollment numbers, we would be looking at, I think it was $57 annually per student, such that students who attend a small school were not more disadvantaged than students who attended a large school in terms of the amount they would have to pay if the school passed it on. So amongst the comments that we received was a comment that was authored by 11 of the CALS deans. And as we were looking at this comment closely, what we concluded was that we wanted to take a little bit more time to refine the proposal because, among other things, what it didn't do was look at the cost, what cost differential should be associated with the accreditation services that we provide for schools that are singly accredited just by the committee versus schools that have the dual accreditation where the work of the committee may be less. Not just on the inspection side, since that's its own fee, but in terms of the things that we're looking for as a committee, that you're looking for, what should that fee differential be? We also wanted to talk about the notion of ending the practice of requiring the schools to pay 1/5 of the deposit for the inspection each year for the 5 years leading up to the inspection, but just require them to pay the complete deposit in the year that the inspection is scheduled. If they wanted to continue to do it the old way, which one school had indicated to me they do, they're free to do that, but they may want to just save the money in a different place and get the interest on that themselves. And we also, though I don't fully agree with all of these particular comments, there were comments that were concerned about that they didn't have all the facts. They didn't think that the State Bar provided all of the information that we should have provided for them to be able to meaningfully weigh in on the proposal. And so we wanted to take the opportunity, in the interest of transparency, sit down with the schools, show them the data, show them how we came up with some of the numbers, talk about the different inspection fee, if you're different accreditation services fee if you're duly accredited, and also talk about the change to the inspection fee. So what I presented to the board in January was that between the January board meeting and the March board meeting, my plan is to invite to a meeting all of the CALS deans and have this conversation, get their input, and then report that back to the board at their March meeting. I would also like to invite Paul as the chair of Ed Standards to join me in that meeting so we can get together the input from the CALS and present the information to them. And so so the update is that nothing was acted upon, but we are going to be having this further conversation to refine the fee proposal for those 2 fees related to the CALS, and we'll report back to you after we conclude those discussions.
Thank you, Donna. Everyone knows this, I believe, except for maybe the last bullet, that the Blue Ribbon Commission recommendations and the portfolio bar exam pilot are before the court, and we should hear back this quarter, I'm saying, but maybe even potentially next month. What you might not know is the CALS, speaking of the CALS, submitted a letter to the court asking for the cut score to be lowered. So that is also with the Supreme Court as well.
First year or?
The bar exam.
The bar exam.
Yeah.
Oh.
They got together and submitted a letter so that the court has that as well. So that's just an update.
Lowered again, wow.
Yes, I can send the committee a copy of the letter.
And did they approach the board of directors first?
It looked like the letter was a follow-up from a request, like the way it was written, and Donna might have more history, but when I read it, it looked like it was a follow-up that they before the court even lowered the cut score during the pandemic, the court had said they could submit a letter about the cut score. So it was like a follow-up, kind of a long-tail follow-up from the CALS deans.
So they went straight to the court without going to the board?
That's correct.
Thank you.
Tara?
Okay, so we just wanted to provide a quick update on the Provisional Licensure Program, or PLP, for you. As you may recall, the court extended the program as well as reopened the application period for the pathway folks, so those who had scored between the 1390 and the 1439. And so they were able to apply between January 2023 last year and December 2023. So we ended up receiving 359 applications. 205 of those applicants are still active in the program, and 78 of them have been admitted to practice through it. So we just wanted to share those updates with you.
Our next meeting is a remote meeting on March 15th. But I also had another recent development, which is this is Donna Hershkowitz's last Committee of Bar Examiners meeting as Chief of Programs. She is taking on another role at the State Bar. If you want to share that role.
Yeah, so I'm actually returning to the role of the Chief Mission Officer at the State Bar. We've been working the past couple of years to really make our legislative affairs program more robust, and it was something that we sort of added on to the program's role, and we haven't had the really the ability to devote the amount of energy to it that we've wanted to. So I'll be taking the legislative affairs program back to the chief mission officer role that I served in for 5 months in 2017 before I switched over to programs. Bridget Grammy, who currently serves as the deputy chief of programs, is going to, you will see her here in this role. She is going to be over what will now newly be named the Consumer Protection, Admissions, Access, and Inclusion
Yes.
Division.
Like CPI.
CPI. So you will be seeing Bridget. She wanted to attend today, but unfortunately, she's at an all-day meeting off-site, and so she couldn't make it.
So org chart wise, does that create another new position at your level?
No.
Good.
I-
We
I
can't
have a-
afford that.
I have a question about the remote meetings.
Yes.
Can you explain, because now there's new rules.
Oh, right. Yes. So as of January, there are the new rules. One of the options was to have all the meetings in person, but budgetarily, we're not going to have all our meetings in person. So we're having 2 meetings in person, this one, and Dr. Cal and Alex are settling on which other one it will be in person this year. And the rest will be remote, but that means we have to go back to the rule where you have to post your address. Either an address that you feel comfortable with taking the meeting from that's accessible, either home or work, or we help you find an accessible location. State bar offices, WeWork, or other kinds of shared workspaces that also allow the public to come in and are accessible.
Donna did such a great job. Can I object?
There will still likely be certain projects, for example, the projects with the Cal fees that I want to tie up, or to the extent that there are other strategic initiatives that the admissions team needs support on as we're going forward. I may very well be participating in some of those. So this is not the last you've seen of me.
Well, that concludes our report, and I think open session.
Robbie, do you have a comment?
Well, I just, Bethany and I were just saying, gosh, we feel like we've been on the Committee of Bar Examiners for 100 years. But I want to say, I guess this is as good an opportunity as any, that having been the chair and the vice chair, one of the most rewarding parts of working with staff has been working with Donna. I have found her to be so responsive to things that we on the committee are interested in. She's the first to integrate them into what we're doing, and she's just a nice person. She's great to work with. She's so thoughtful and smart, and if this is your last meeting, I just want to say, I think I speak for all of us. Thank you and congratulations, and good luck on what's next.
Thank you.
I have another question about the remote meetings. What about that whole thing of like half the people have to be in a certain location?
Was that the non-advisory?
No, so that was an alternative. Under the statute, there is an alternative to having to post your addresses. And that alternative is if the majority of members are located in the same physical location, then the remaining members do not need to post their location. However, that also is a budgetary implication in order to get half of the members in one location. And so that is something that as an entity, we determined wasn't feasible. And so we were going to have, other than these in-person meetings, these couple of in-person meetings, the other ones were going to be fully remote.
And for
Unless
those
you
of
don't-
us who don't have an
unless
accessible
you-
location.
Right, right, so then you're gonna have to go somewhere. So I live 10 minutes from here, so I would come here.
Mm-hmm. Yeah.
I want to piggyback on Robbie's comment. It's been such an unbelievable pleasure to work with and to get to know Donna, what she's done for the committee. I mean, Robbie and Bethany and Alan and Paul have been here for 120 years. For us, we're the newbies, and it's been such a pleasure to be able to work with Donna. She is so so nice, like what Robbie said, and so easily approachable, and her wealth of knowledge, her fund of knowledge, and just an incredible person. We really are going to miss you, Donna. Thank you so much for all your help with each one of us, as well as for the committee as well.
So I did want to be clear about one thing, and so this is sort of part of a restructure that we're going through, and one of the reasons that leadership feels very comfortable with this restructure is the faith that we have in Audrey Ching in running the show here, and so we know that you are in very good hands with Audrey. So I didn't want to fail to mention that.
Thank you so much, Donna, for all your service on the committee, and we're definitely going to miss working with you on a daily basis, and definitely Audrey's phenomenal. I've had the privilege of working with her very closely, so has Alex Chan. So when we prep for these meetings, we talk about issues, and I echo what Donna said. You know, Audrey is on top of it, and it will be a seamless transition. So I'd like to go ahead and I think it's time for lunch. We're a little behind schedule, so let's grab for lunch, and then we will be back in an hour, right, for the public, or how?
In closed session, or do we need to come back to open?
We can go directly into closed.
All right, so we are going to take lunch for the public for an hour, and then the committee will then go directly into closed session. Thank you. Is there any more business? Okay, the meeting is adjourned. Our next meeting will be on March 15th, 2024. Thank you very much for coming and attending today. Thank you.
Thank you.